posted to the appropriate court. Item 43.
List the matter before the appropriate bench.
Maybe mentioned.
Who had earlier heard the matter, no, comma, since it is submitted that the matter was extensively heard by another bench.
Justice, otherwise, again.
We said it was extensively heard by another bench.
Yes. All right.
Yes.
Other tried this for other side.
Bring for listing of this matter for admission lots.
For
Admission lots. Of this list.
this is civil bench 2 or civil bench 3 matter.
3 lots.
Civil bench 2. Yes.
May I plead your lordship? I recommend item number 37, the consent of other side. Lordship, kindly letter may be adjourned for the day. And
You are appearing for the petitioner. But this is a 22 matter. This is a 22 matter, madam. The request of the petitioner with the consent of the council for the list this matter again on 11th of July. 11th of June. 2022.
Lordship, may
Yes.
please, Lordship, please the matter for admission, matter are related to regularization of service.
Then I'm told there is a senior bench. Hello. Silence. Yes.
Function of the others are recommendation for the eight.
8.
Council.
Huh?
Council is
The request of the London Council for the petitioner list this matter again on when? June 24th of June.
Item number
18.
18.
Both, huh? 8 and 18. Yes, sir.
And your lordship, here two matters have been listed before your lordship for AB. And in both these cases, case diary was called for, which has not been received. So if lordship fixes a date, you can produce the case diary, lordship.
What are the
25 and
items?
26.
Item number?
25 and 26.
I mean, I did not 25 also.
I mean 26.
CD is available.
My lord, in this case, on the last of this, my lord, his lordship was, my lord, pleased to, my lord, intended to, my lord, grant interim bail, lordship, because one CD was not there, lordship. But these are the PP, my lord, too short date, my lord, bail, lordship. My lord, my lord, where is my lord, today, my lord.
How soon can you have it?
Next week, any date?
My lord, I may be protected, my lord, senior citizen, lordship, this is the case, my lord, there was group, my lord,
You remember it.
my lord.
There were two cases. In one cases, your the owner of the land,
Lordship.
there was a title suit. The owner of the
Yes,
land
sir.
is also involved. He is injured. He has given some
My lord,
photographs.
quarrel
Do we need
between
to
my lord
remember-
plaintiffs and
do we need to remember more?
I am the third party, lordship.
Yes. And we had
Chief
also
Judge,
discussed
yes,
that you not being involved in the land in any matter, were present there trying to beat up people and everything. We discussed all this.
If quarrel is just
Yes.
many people
So-
come, lordship.
So we remember, we'll have it on Tuesday next. On Tuesday next, let him have his CD.
My lord,
Unless both the CDs are there.
my lord, senior citizen.
26 of the law.
26.
Say maybe, my lord, protected lordship, for the, till next date, lordship.
That cannot be, lordship. The
My
previous
earlier
issue is
also,
there.
the lordship, wanted to, my lord, grant it in the lordship. That is why short date was to be,
The previous injury is there, lordship.
that might be, my lord.
Let it be on Tuesday.
No intention is there, group, my lord, quarrel between two groups, lordship. That is why, my lord,
I think one of the persons had died also.
Yes.
yes, lordship, that,
That is why, lordship, CD may be
my
called
lord,
for.
5 persons have been arrested in this case.
Would you like to have it on Tuesday?
Lordship.
Let's have it on Tuesday. huh? Let both the CDs be here. We'll see what is the developments against you. If they have anything which requires a custodial interrogation. If not, Tuesday you have it.
Lordship.
Yeah.
If the request of the learned counsel, learned APP who has submitted the CD is awaited, please this matter again on Tuesday, the 2nd of June, the learned counsel for the petitioner has submitted. This is, you are in item number
25.
25. Learned counsel for the petition, this part only in item number 25. The learned counsel for the petitioner has submitted that the petitioner is a senior citizen. Instead, the APP will take note of the matter and will invariably produce the case diary called for. On appealing which, invariably produce the case diary called for. Next day,
26 also.
I've seen 26, you just said that, the first part of it, na? The first part of it. List again on 21 2nd of June.
No, blood switch.
Yes,
Let's see the events of the. That. I have instruction.
Mr. Ahmad Kundakal and counsel agreeing for the petitioner has submitted that he is under instructions not to present the repetition in its present form. Good stuff. Accordingly, the repetition is closed. And is not placed.
And
Lordship, I'm M. Das appearing on behalf of SK Medi for the respondents.
Take her attendance. Ms. M. Das appearing for Mr. S.K. Modi for the respondents does not object to the prayer for withdrawal.
and.
Obliged, dear Lordship.
Yes, sir.
There are events that are in the same shape, but arising not separate, giving rise to separate cause of action. But the first case is with the petitioner working in post impact of administrative post. Out of them, one from which he was removed earlier. That of course was not challenged. Subsequently, he was removed from another 3 posts. There is a post to be HOD as well as the nodal officer revoked. There is a vocational training. That order will be challenged. Now, the basic ground is that the order is without product input. And secondly, it's stigmatic in nature. Therefore, the manner in which was or past, it couldn't have been done. First one. Secondly, when this case was pending, it was put as a suspension. That suspension we have challenged again, authorities again the question, and no ratification as per Judge Chaudhary in document. And third case, is that show cause notice was issued. Now, we sought some documents. They furnished some documents. That's we received or we're inspecting. We sought certain documents saying that these documents are essential for our reply. Partially, some of the documents have been given, but some other documents have not been given. So one of the important one, just give an example. One important document with regard to the formation of the issues, the show cause. The first show cause. They say the file is not present. So there are other documents which have not been given to us. I'll come to that one. The first one is a case where I was been removed from 3 posts. Now,
This is the suspension part.
Madam.
Are you reinstated in service as of now, or you are still under suspension? Can that be carried on? Let us first see the suspension.
Yes.
We go one by one. If we break it up, maybe the load will come down.
Yes, madam.
It looks
Suspension is about 621.
6218.
Yes. Page 69, madam. And extra 20 to page 69. I was told that suspension.
Yes.
Disciplinary proceeding is Professor Lakshmi Narayan Sethi, Department of Engineering. It's confirmed as per EC resolution number so and so. Dated with 151st resolution. Now therefore, the competent authority in exercise of powers conferred upon him by Rule 10(1) CCS CCA Rules 1965 and Acts and Statutes for University of Global Cases, Professor Lakshmi Narayan Sethi, Department of Agriculture, Engineering and Suspension, immediate effect in accordance with EC resolution 151, dated 5/8/2022, on which date the order is coming in him. Now, will be paid subsistence allowances per month. So just point out one thing. He's still receiving 50% subsistence allowance. We paid 75%. That was also not rejected. Now, page 72 is the EC resolution. It starts at page 70. It's at page 72, but with regard to Professor Sethi. 149 meeting of the Executive Council with its so and so by resolution number 149 resolved to remove Professor Lakshmi Narayan Sethi from administrative positions post with immediate effect. Accordingly, by order number so and so, dated 31/5/2022, Professor Narayan Sethi was released from the position of Dean, School of Technology, Head of Department of Agriculture and Engineering, and Nodal Officer revoked with immediate effect and was asked to hand over charge of this. Now, this is important. He asked to hand over charge, that is, official documents and other essential materials. However, in spite of repeated reminders, Professor Sethi did not hand over charges, that is, official documents and other essential materials to the Dean, SOT, and in charge IC Agriculture and Engineering, Nodal Officer revoked. This is seriously impaired the function of the department in the university. Because further observed that Professor Sethi also did not hand over charge. Official documents files of the room they allowed to the liaison officer, to Dr. Paramita Das, who was nominated liaison officer. Now, this was an earlier removal, which of course I have not had much challenge. Considering the seriousness of issues, the council unanimously resolved that in defiance of the directives of the Executive Council on the university administration is strongly dealt with to ensure academic discipline and smooth functioning of the system. The council therefore recommended the suspension of Professor Ellen Sethi and the solution of immediate inquiry for service rule. The council authorized the vice chancellor in this action. Because the council also directed the register of university weakness arrangement for recovery of files and other for smooth functioning of the offices. So my case is that I have been after I was removed, they took over charge and they were functioning normally, without any hindrance, and this issue of fee, etc., not being handed over. So I had said that these are all already the department, and these were all very much there. And in spite of that, this order was passed.
When was the charge sheet given to you?
Well, a charge sheet was
No, it's actually. So this is a copy of charge sheet.
the 83379 challenge. Charge sheet page 28, of the WC number 8337.
Is it 4th of November, sir?
Madam.
4th of November?
Sorry. Yes, 4th of November. It's 4th of November. It's by page 52, madam.
Yes, thereafter.
Yes. Madam. Memorandum, it starts with 50, page 54, madam. 4th of November 2022.
No, I have got the WPC number, WPC where you have challenged the suspension. Let us not go from one to the other.
Fine.
I just needed the
Fine.
date. Has there been any review of the suspensions here? When?
Recently on 18th of December 25.
On 10th of December, you have reviewed.
Lord's
it.
earlier lots also we have.
Ah, tell us that.
Yes,
Don't
Lordship.
give us half the dates. Tell us the date, first date of
I have the.
review.
I'll place all this.
Well, the first review.
Tell us this.
Yes.
Give us the date.
First review, my lord,
Ah,
took place, my lord, on the 106th day, madam. Page, my lord, 259 of the edition by heading.
filed in which this case only?
5 minutes.
Of this case itself?
Yes,
Page 100 and
259, my son. Edition by-
259. Mr. KL, please ask your juniors to tally the dates.
Lots.
We don't want the confusion also. Whatever we are hearing now, we are taking it to be a
Lordship.
final date.
I'll assist you.
At least the facts, we
Yes.
will not go back again.
Lots.
259.
First review of.
Page 250?
First
Fifth, 259, my lord, this is the third, my lord, it is 22nd November.
November, yes.
It's an EC resolution, madam. 153rd meeting.
Where do you find your
My lord, mine will be, my lord, page,
resolution?
my lord, like page 264. ma'am. Dr. Lakshminarayan Sethi, Professor, Department of Agriculture, Engineering is placed under suspension by order number 12 so dated 8th of August 2022. ma'am. Subject to the decision of the Executive Council, the competent authority will extend the period of suspension of Professor Sethi to further period of 90 days. From the date of completion of the initial period of suspension under Rule 10(6), CCA Rules 1965. By order number 4th November 2022, this item was placed with the council for ratification. The
Where
council-
is that order dated 4 November 2022?
4th November 2022, that's not the next.
Further period 90 days from the date of completion. Yes, this competent authority has extended the period of suspension. Where is that order? The order which has extended the suspension.
Let's wait.
Now,
That is-
just
that-
ask them to keep it ready.
Yes.
That is by the BC, my lord. That is by the BC. That is, my lord, extended, my lord, on, my lord, that is by the BC, my lord.
Yes, sir. Then what will you say, Mr. Doctor?
5 minutes.
You can carry on, yes.
Man.
Just
Now, then, my lord,
Hmm.
the register extends the second, register when it extends on second time, my lord.
Hmm.
2023, page 256, man. 256. Two, 350, my lord, 3rd of February 2023, my lord. That is the second time, my lord. This is by the register. With the disciplinary proceeding of Lakshminarayan Sethi, Department of Agriculture is pending, the order of suspension.
You are a professor.
I'm a professor, my lord.
Who is the authority, who is the competent authority to hold the decision?
EC, man.
Huh?
EC, Executive
EC.
Council is the appointing department. And registrar my lord is junior to me. In the hierarchy, registrar is junior to me.
Okay.
And my lord, the power of the BC is also, my lord, circumscribed, my lord. He can only act in immediate, my lord, situations. There is a judgment of this honorable court. My lord, where only he can act in immediate situations and has to report to the EC. Otherwise, he cannot, my lord, act. No, it's a discipline, it's the EC with the discipline department. Now, lordship has seen the first, my lord, ratification by the EC, my lord. That EC resolution shows that no reason has been assigned. That is, it's only said EC has ratified. There was mechanical malot. First of all, there was mechanical malot rectification, page 250, malot 264 that I have just shown. Malot. And secondly, malot, that was beyond malot 100, beyond 90 days. Malot. It was on the 106th day, malot. Because you were suspended on 8/8/2020, the first suspension. He was suspended on 8/8/2022. The first extension was 4th November 2022, malot, page 255.
Just 1 minute, sir.
Of WBC. This is the part of our affidavit and reply, page 255.
Fifty-six is 3rd of February 2023.
Yes.
Second extension.
Second. Extension. Now, what you will see, madam, this is at equal to 56, madam. That is the order. And my lord, this second suspension was ratified, my lord. This was after 91st day, madam, from the first suspension. 4th November was, my lord, 4th November 2022 was the first, my lord, extension. Then this is the 91st day, my lord, was extended. Now, my lord, EC ratifies, my lord, page 270, madam. This EC ratifies on the 97th day, madam.
Page 2,
270, madam, it starts.
the second one.
Second one. 270. One 55th EC, madam. And madam, mine is another page.
272.
It's a 97th day, madam. Done.
27th of February, na ratification.
That is 27 to 2022.
No, 23.
That is at page 270, madam. First, resolution number, item number 3, madam.
Same.
Again, madam, here, the council tables the matter and ratifies the same. So there is no application of mine, no review, nothing of the sort, madam. Was placed before the council for ratification, and this is the minus of the council. So therefore, the minus of the council do not reveal, madam, any discussion or something like that, any review, any application of mine. It says only peruse the matter and ratify the same. Then, my lord, third extension, again by the VC, sorry, the registrar. That is at, my lord, page 283.
When the registrar's order says the competent authority
Madam.
extends, hereby extends.
Now, who is the competent authority? There is no mention.
Hereby is by this letter. Hereby would mean this letter.
This letter, yes.
Cannot mean some letter which is.
No, some of the local. So who is the competent authority? And ratification always comes afterwards by the EC.
Then when is the third one?
Then third one, my lord, third extension of the registration law, page 283. Subject to ratification of the executive council, the competent authority in exercise of the powers vested upon rules so as amended from time to time the powers conferred in the act, hereby extends the period of suspension of Professor Lakshmikant Lakshminarayan Sethi for a further 180 days in continuation of the earlier suspension order referred to the immediate effect. So again, my lord, now whereas during the period of suspension, professor will not be paid subsistence allowance at the rate of 50% that remains unchanged. Now, my lord, this was rectified, my lord. On, my lord,
291.
this is dated by the 31st of July. This was ratified on 14/8/2023, my lord, page 284. The next, my lord, next shot. Page 291. Is with regard to Professor Sethi. The details of the actions of the university, last paragraph. The details of the issue were tabled during the meeting for the consideration between the council. The details of action taken by the university with respect to suspension of Professor Evan Sethi was placed with the members of the council, which was taken note of and ratified by the council. That much. Then, my lord, fourth extension,
When did it come?
21/5/2024. This is on, my lord, page number 312.
Repeat one.
312. Connection. 312. Whereas the disciplinary proceeding is Professor Lakshminarayan Sethi, Department of Agriculture Engineering, Assam University is pending, and the order of suspension is forced. Now, therefore, subject to ratification by the Executive Council of the University, the competent authority in exercise the powers vested upon rule number so-and-so, amended from time to time, as it hereby extends the period of suspension of Lakshminarayan for another period of 180 days. In continuation of early suspension, as referred to the immediate effect, the date of completion of third extension period issued by so-and-so, so-and-so. Now, the subsistence allowance remains unchanged. Now, this notification, my lord, 25th January, after that, my lord, this extension, my lord, was not ratified. This is the fourth extension. This was not ratified. Then, my lord, the fifth extension, my lord, is page, my lord, 313. This is 19th/7/2024. Again, because it says the same thing, subject to ratification of the Executive Council of the University, the competent authorities in exercise the powers vested under Rule 10(6) of CCA Rules 1965, as amended from time to time in the powers conferred upon by Act and Statute, so hereby extend the period of suspension and the powers conferred period of suspension for Professor Lakshminarayan Sethi for a further period of 180 days in continuation of early suspension or referred above with effect for the date of completion of the fourth extension. Now, this is the 19th July, my lord. Then EC, my lord, sits on 24th of July 2025. 24th of October. 24/10/2025, page 315. 317, my lord, is the relevant portion. As disciplinary proceeding against Professor Lakshminarayan Sethi is pending and suspension is enforced. Further, the listed extension period is completed on 24th of July 2024. Accordingly, subject to ratification in the Executive Council, the competent authority has extended the period of suspension to further period of 180 days. As per this action settled the university in continuation. In continuation of the earlier orders of suspension, the basis of committee report considered the terms. The item was placed with the council and for the ratification, the council is ratified. So again, my lord, without any application of mine, this was again extended. Now, this way, my lord, this same similar orders have been passed, my lord. Now, my lord, it has been for the 8th time it has been extended. The 8th extension, my lord, of course, now it's not brought on record, my lord, because it's happened afterwards. Number of affidavits are already filed. It happened on 9/1/2026. Of course, my lord, that period is yet to be over. Now, my lord, seventh extension was ratified, my lord, on 25/9/2025. That is also not, my lord, brought on record.
9/1/26 was the 8th extension or 9?
9/1/26 is the 8th extension. 8th. 7th, my lord, is
6. Yes, now what is your ground of challenge, sir?
7th one is 10/7/2025. And my lord, 2-hour information, my lord, 7th extension has not been ratified as yet. 4th and 7th extension have not been ratified by the Executive Council. So therefore, my lord, you will see, my lord, all these ratifications, the first ratification, my lord, took place on the 106th day. Second one, my lord, on the 97th day. Third one, of course, my lord, was within 168 days. Fourth one, my lord, was not ratified at all. So, my lord, Sixth extension, my lord, was ratified after 182 days. My lord. So, my lord, these are, my lord, the manner, this is the manner in which, my lord, they have been extending this, suspension beyond, my lord, the period, my lord. Prescribed 90 days or 180 days is the case, my lord. See, it's because the subsequent extensions for 180 days, which the most they can do. Therefore, my lord, this were not done in time. So, my lord, Ajay Chaudhary and Deepak Mali clearly comes to the picture. Now, my lord, so far as, my lord, the initial order of suspension is concerned, page 69, my lord. 8/8/22, my lord. This was in accordance with the EC resolution, my lord, which of course, my lord, at that point of time was not, my lord. Sorry, that was that's at page 72. Now, my lord, you can see, my lord, here. These are with regard to, my lord, the team not handing over, my lord, some, my lord, the charges of the post of, my lord, nodal officer, my lord, head of department, and dean of schools, my lord. But, my lord, the show cause that was issued to him, that was in with regard to, my lord, two other action, my lord, charges. One, not, my lord, forwarding the applications or not, my lord, considering the, my lord, staged, conducted the viva voce, or one Raktin Dev, a scholar. His PhD viva voce was not carried out. His alleged that I had delayed the process. And one Ajita Tiwari, whose career advancement scheme application was not processed in time. That are the two allegations that we made. But these are not a part of the EC resolution, which Lordship will see at page 72.
There were 4 articles against you.
5, in fact. 5 articles.
4.
3, my lord, with regard to not handing over these charges. And my lord, 2 with regard to, my lord,
Article 1, Article 2, Article 3, and Article 4, I think. Anyway, yes.
so basically the charges are that those 5 charges are there that he did not hand over. And also additionally, my lord, that he did not hand over the post of liaison officer's charge. That was also, my lord, brought in. Now, my lord, may I just point out here?
Yes.
His removal from the post, my lord, the administrative post, was with regard to the charge of not handing over, my lord, the post of from which was removed. 3 posts. 2 tenure posts and 1 non-tenure post, which was removed. So that was there. Our lordship will see, but so far as the EC resolution is concerned, as the lordship seen that this was issued, and after
You were placed under suspension in contemplation of a disciplinary proceeding. They have the authority to do that. This order was issued by the Vice Chancellor. So the authority to suspend you is not in question.
no, my lord, it has to be by the ECB.
Suspension can be placed, you can be placed under suspension by any authority superior to you, which can be ratified by the.
Yes,
So that part,
there can be.
I think 882022
Madam,
being ratified on a later date. Or because it was on the directions of the EC,
madam,
that resolution,
madam. That, my lord, that yes.
that authority to place you under suspension
Was given.
in contemplation of a disciplinary proceeding, perhaps we will not
Because
interfere.
it says that the council authorized the vice chancellor to take selection accordingly. So it was as per the.
That was okay. Thereafter,
But the subsequent bill of ratification by the
now
extension.
the ratification would come only after the extension is done. Now, that extension could have been done by the registrar or could not have been done by the registrar, or that it was done, a registrar had only issued the notice, but there was already a direction to extend it. I think that is where the crux.
Exactly. Those things are not on record.
Huh.
EC resolution is what we are having before us, because it says subject to ratification by EC. So therefore, it clearly implies that the EC has not ratified it till then.
EC did not say that it needs to be extended. Who is your disciplinary authority?
EC. Because EC is my appointing authority.
Do we have the rules of the university? Disciplinary, the service rules of the professors.
Assam University access and
Where do we find
under the act, my lord,
the disciplinary authority of the
the so the vice chancellor, my lord, vice chancellor's powers, my lord, at page, my lord, 10, my lord, of the page 10, my lord, of the 12. 12. Page 12, my lord, but vice chancellor shall be appointed by the VC, that's not important. 3, my lord. 3. The vice chancellor, if in his opinion that immediate action is necessary on any matter, exercise any power conferred on any authority of the university by or under this act, it shall report to such authority the action taken by him on such matter. Provided that if the authority concerned is of the opinion, the such action not to be taken, it may refer the matter to the visitor, whose decision shall be final. Now, my lord, the vice chancellor's powers also, my lord, the executive council is, my lord, under 20, my lord. And its powers are, my lord, prescribed by the statute. That your lordship will find at page. Serial number 12. Executive council, madam. Powers and functions of the executive, page 16 of the, my lord, statute.
page?
Page, my lord, 16 of the statute. Powers and functions of the executive council. The executive council has the power to management and administration of revenue and property of the university and conduct institutions. So, then subject to the provisions of the statute and the ordinance, the executive council shall, in addition to the other powers vested, have the following power, namely, to create teaching and academic posts, to determine the number and emoluments of such posts, and define the duties and conditions of the post services of professors, associate professors, assistant professors, and other academic staff, principal of the college, institution maintained by the university. Then we have 2, my lord, to appoint professors, associate professors, assistant professors, and other academic staff as been necessary, and principal of colleges and institutions maintained by the university on the recommendation of the selection committee constituted for the purpose. So, my lord, the appointing authority is the EC. So, for example, the professors and teachers are concerned. And the power to delegate is there, madam. To delegate the inhumous powers to the vice chancellor is there, but page, that is on page 18. Page 18. Serial number, my lord, Roman, my lord, 16. Third from the top.
Is the grounds of challenge for the suspension what remains? Your ground is that it was extended without ratification and was ratified later.
Later.
So you are challenging the power to extend it by the registrar.
Because it was clearly specified that it is subject to ratification the EC, which apparently for the records is shown always came later on.
Hmm.
And after the period of,
After the period.
after the period of.
Yes, sir. Is the registrar authorized to extend?
Approximately please to see the order.
Hmm.
Second. It's page 313.
We are not stopping you in your arguments. We are just trying to clarify it point wise.
Lots.
So that what to concentrate on, what not to be understand. Yes. Where is the authority? This extension, the
Page
first
313.
extension?
Fourth extension. I'm
No.
just showing your how the order was passed.
No, the first extension was on 4/11/2022. Where is that letter?
Lord, page 255.
255.
255.
Hmm. First, tell us who is the competent authority?
VC.
The VC.
VC.
Where is the letter of the VC?
Lordship.
Or the file noting of the VC saying that it should be extended?
No, Lordship may please to see first order of suspension.
That is it. We are not interfering with the first order.
Second
Of
Lordship,
suspension since the VC has the power. Since the VC has the power to place him under suspension because he is an authority superior to the petitioner.
petitioner.
And there was a contemplation of a disciplinary proceeding prior to that order being passed on 5/8/2022. EC had said we are holding a disciplinary proceeding. Please suspend. Thereafter, before the 90th day,
It is to be
an authority who was empowered to extend it. The VC had imposed that, had passed that order of suspension because the EC required him to do so.
Lordship.
It was not the VC's mind to suspend.
Lordship, correct.
It was the direction of the EC.
Yes.
So the EC has the power to suspend. Now, the extension has to be considered by whom?
By the review committee. Normally, Lordship, as per the
You
direction.
do
of
not
the-
have a review committee apparently.
Initially, it was not.
There is no,
Subsequently,
when
Lordship.
that will come subsequently. We will go on every order. Wise.
Yes, sir. Initially, Lordship, it
The
was
first 4th of November 2022
4th of
at
November.
page 255.
Yes, Lordship. May I read?
It says subject to ratification of the Executive Council. Now,
Now,
so now the Executive Council is yet to take a decision whether to continue his suspension or not. Is it not?
no,
This
Lordship.
order will require to be ratified by someone.
Yes,
So there is no decision of the Executive Council to extend it. It will only be taken after the order is passed.
yes, sir.
Ratification.
Yes, sir.
So till this date, there is no order which has, no order from the EC.
It was
Now
not.
the
ready.
VC takes a call that I want it extended because of the discipline proceeding. Where is that note?
That is not there.
If the VC, if the Vice Chancellor has not taken that decision,
Okay. Okay, the vice chancellor has authorized the registrar to act on his behalf. And then-
A person who is lower in rank to the
No,
professor.
Lordship, DC has power authority under the institute.
Someone who
No.
is,
Registrar, Lordship, as per the hierarchy of the post,
Huh?
he is the superior to the petitioner, registrar.
where do we find that?
He was the dean, my lord, so therefore he was the speed.
No, Lordship,
Huh?
cannot.
Yeah.
The VC, first Lordship Chancellor, then VC, then registrar, then other, because he is the administrative, holding the administrative post.
My lord, officers of the university will page 10, my lord.
That is what we will look
Page 10, my lord.
of the statute
Act.
of the act.
Act, my lord. Officers of the university.
Yes.
Chancellor, vice chancellor, pro vice chancellor, dean of schools. So he was the dean of schools. Then the rest.
And that is the first thing.
Not
Now your argument will also not stand, perhaps, what we understand.
not
Please come to the second last paragraph,
255 page.
page 250.
Not
He will not leave the headquarters without obtaining the prior permission of the competent authority.
That is very-
Vice.
vice chancellor.
So the vice chancellor is not given in the authority.
Lordship may please to see, this is the letter dated 9th August 2022.
That is after 4th of November, 9th of August. it's-
August 2020.
Where do we have that?
Yes, sir. Report picture, no. This is the original
There
record.
is another question, perhaps, whether a delegate can be further delegate.
But somewhere we saw that he can do something like that. You were showing us the powers of the VC, na?
Yes.
Where was it?
12, my lord, 12 will be sent.
You- Page number 4 of the statute, if I'm not wrong. Subpara 4.
The vice chancellor controlling the affairs of the university has the powers to necessary for maintaining proper mental discipline in the university and may delegate such powers to personally take the power. But that power, my lord, that the judgment of the Supreme Court, it says, VC's power is limited only to immediate necessity. If there is something which cannot wait,
They say under 3.5.
3.5.
3.5. That is what we had seen here, 3.5, that the VC can delegate.
Lord, so far, that is so far his powers, Lord, his own powers are concerned. Question will be whether a delegated power can be further delegated. So far as this, the BC has his own powers also. So far as Lord, the other staffs are concerned, my lord, the BC has the power. BC's power, my lord, will be to delegate his powers. But something which has been already delegated to him, whether he can delegate BC's powers to another person, that is another question. The vice chancellor have all the powers, this is necessary for mental discipline, and he may delegate such powers to any such persons that we give him. His powers to maintain discipline, whatever power he has, only that much he can delegate.
Yes. Now the other part that he was this registrar is a person who's junior to the petitioner.
If
The
the,
petitioner being the dean of schools. Is the hierarchy shown in the act?
Lordship,
The hierarchy which is shown in the act,
Lordship,
the dean of school is on a higher position.
Lordship, even then, Lordship, when that VC has power to delegate his power, then Lordship probably,
Juniors cannot be extending suspension, so it will be a, it
No,
will be a
no,
very huge, it will have a very huge
no,
impact on
Lordship,
service.
so see, he's acting on the advice of the VC Lord, not his own decision. Lord.
Now this, this approval of the vice chancellor prior to 4th of November 2022, where is it?
Lordship,
At page 255,
Lordship,
the last line reads, this is issued with the approval of the vice chancellor. So there must have been a note.
Lordship.
Furtherance, there must have been a note
Must be,
that we need to extend it.
it must be available in there.
And you have
I
it.
find out. What is it? That's it. What it can be. 4, 11 to 32.
But it is not matching up, Mr. Dayal.
What's it?
He says, the competent authority hereby extends the period of suspension. At page 255, second paragraph.
Now the subject to the
Competent authority in exercise of the powers extends the period of suspension. Then he says you shall not leave without permission of the competent authority.
Yes.
Then he says it has approval of the vice chancellor.
Not
Who is the competent authority?
Vice Chancellor. Okay.
Then how does hereby extends?
See, because authority has been given to him. So he is acting on the advice of the VC.
That notice there?
Okay. It is yes.
So you are saying that the registrar has the competency to issue the letter? Definitely VC will.
On the advice of the VC.
Then why did VC issue the first letter?
4/11/2022. Notice there.
11.
Yes, sir. It is there. Below.
Word of November. Yes,
Oh, it is there. Lord.
the approval of the VC is there.
Done.
For the
Page 72.
page
Page 70.
72.
Yes, the initial VC.
Huh.
The council therefore recommends for immediate suspension of Professor LNCK in his inquiry as per service rule. The council authorizes the vice chancellor to take as action on. Now, my lord, subsequently, my lord, this is only, my lord, for the purpose of, to the extent of, my lord, granting the power to suspend him. It cannot be said, this power is a continuous thing, that it will continue for all times to come. Otherwise, the very fact, they've been issuing this order subject to the ratification of the EC, that contradicts their own stand. Because subsequent
The
suspension,
ratification was not done by the VC himself, because required to be done by the EC, therefore the VC never had the power, and therefore
Yeah.
the VC could not have
Yeah.
delegated it to the
because
registrar.
this resolution did not say that for all times to come, this will be continued till the matter continues. It was only for that purpose of suspension. Accordingly, he was given the power to issue necessary instruction or orders, take necessary action rather. Subsequently, when they extended the orders, it specifically says that subject to ratification by the EC. And secondly, my lord, it is not just about ratification, it's about exercise of mind, my lord, application of mind. It cannot be a mechanical process. With the vice chancellor, the note goes to the vice chancellor, and I have not seen the note, my lord, that is not a part of the records. We have not filed with the affidavit. But that note, my lord, simply by saying that we extend, that will not be sufficient. There has to be an exercise of mind. The EC's resolutions also do not reflect any exercise of mind. Simply, my lord, mechanically, yes, it has to be extended. The council ratifies. So therefore, my lord, this and the orders itself, the extension orders themselves, my lord, say that it is subject to ratification by the EC. So therefore, it is implied that the vice chancellor also knows, my lord, that it had to be ratified by the EC. And that ratification, in my humble submission, has to come within this period of 90 days or 180 days, as the case may be. Because initially it was for 90 days, so they had to do it within 90. When it was 180 days, they had to do it in 180 days. So
The ratification.
ratification, since the earlier extension was there, so they have to do it in the period. And at the initial stage, when the ratification was not done, that there itself suspension will order approval.
Otherwise, the issuance of the order by the EC, by the registrar is within the time frame.
Yes, first one has been 88th day. 4th of November is 88th day.
Huh.
Then, my lord, second was again, my lord, 91st day, my lord.
That is what we are asking.
That is again gone, my lord.
That is what we are asking.
Second.
Go with something we can calculate.
Right.
Because see,
First one is
the
88th day, my lord.
ratification can come at
88.
any point of time.
And, my lord, the EC, my lord, extends it, my lord, from.
Not the EC, the registrar's order, does it extend 90 days in any of the extensions?
My lord, first extension is 4/11, my lord. Then 3/2/23. 3/2/23, my lord. It happens, if I'm not wrong, for the 91st day. 91st day. I calculated it.
And Mr. Kayal, you would also perhaps have to answer.
Not so.
If you come to page 264, one argument is making us consider the situation. Page 263.
262.
264.
Yes. Sir. Extension of suspension in respect of.
You see, there is one sentence, the council ratified the same.
Not so.
Immediately below that, council had a thorough discussion on the matter. You see the next resolution?
Yes.
Yes.
Yeah, it is.
Now, we have noticed that wherever there were some reasons given in the proposal,
Extension.
wherever there is a reason, this is why the action was taken.
Yes.
Council goes by one line, saying council ratifies the same. If you come to page 263.
Not so it is there.
263, appointment of so-and-so. Granted him lien. Because he continues there, we grant him lien. They say in one line, ratified the same. But where a discussion is required as to what is to be done, council discusses it at page 264, the second resolution regarding Murali Basa.
Yes, sir.
They make a discussion.
This was also an extension.
But for this item number 7, the first one,
Only one line is there.
one liner, and they also do not say why the suspension is required. Whether he would interfere in the disciplinary proceeding, whether he would make the papers vanish, whether he should not be allowed to work. He is a professor,
Obviously.
but administrative he should have been there. Because the office note that we have seen, that also does not reflect why the extension was required.
It was simply placed before the BC and he has approved.
So extension, when you are putting a person on half the pay,
Lordship, here I want to rely on Ajay Chaudhary judgment, my learned will also rely. Lordship, in that probably that will also come to rescue my, in rescue. of
that
my-
it can be a simple one-liner.
No.
Yes, extended.
No, Lordship, here what happened? Lordship has seen that he has approached thrice this honorable court. One, writ petition that he has been removed from his from additional charges that he is aggrieved. Second is challenging the suspension. Second, Lordship, even charge sheet is issued. He is asking for some documents, although documents relied by the university in charge sheet has been supplied to him. He is asking for an extra.
That part is otherwise. We are just asking
No,
that
Lordship,
when you extend someone's agony,
Lordship,
how do we read the mind of the university when he alleges that it was not done in the proper manner? How do we assess that? It has to be somewhere on the paper.
no, definitely.
Now, if if this item number 7 had carried a sentence saying that extension was because the disciplinary proceeding, he was not participating in the disciplinary proceeding, or he was trying to delay it, or he was trying to remove the papers, or allowing him now to join it, create a chaos. Something, nothing is there. The notes say nothing.
No, it is Lordship admitted that nothing is there. So perhaps the reason that Lordship, because he has approached this honorable court and this honorable court has passed an interim order that university will not insist on filing a reply against the charge sheet. Probably this is the reason Lordship.
The extension is going on.
Yeah,
The documents are all with you.
yes, no, documents has been supplied. to him.
No. The documents on which you would rely
Yes,
are all with you.
yes, Lordship.
He did not hand over the charge. Now it is being taken over. It has already been taken over by someone. Someone is running the university. He is not doing any duties, so someone is running the university. Yes?
Yes, that is.
Now, you do
Some-
not,
Some the charge he has, still he has not handed over to the. That is. that
then
is-
you will assume charge. You'll break the lock and you will assume charge. You will not keep the room closed.
No, Lordship, somebody is, Lordship, Ajay Tiwari is working in his place, but some documents, still he has been kept by the petitioner. That is my instruction.
But keeping him under prolonged suspension.
Lordship is to see the circumstances, whether it can be said that this is a prolonged suspension. Because charge sheet was issued to him in 2022. Till date, he has not replied. The
Because
ground,
of the orders of this court.
no, Lordship, even the Lordship, we have supplied all the documents which are relied by the authority.
That is, whatever he has not done, he has taken the authority from this court not to
No,
do it.
Lordship,
Like the registrar took the authority from the VC, the VC took it from the EC. So he's under authority not to reply till that is vacated. Tell us why you need to continue suspension.
no, Lordship, because the procedure, three matters are pending on this, and this is the only reason because he has not allowed the university to proceed with the disseminate proceeding.
So keep him under suspension.
Lordship, probably, perhaps this is the reason.
That will be a very awkward situation, sir.
No, Lordship, see the sick.
That would be saying that because you have a stay, we'll keep you under suspension.
No, Lordship, please to see
Not a
that.
very bona fide.
And my learned friend is saying, say it all, probably.
Yes, Lord.
That is his impression.
Tell us the reason
That is
why,
the records.
tell us the reason why the extension was granted. What was the reason why the extension was required? In a disciplinary proceeding,
Lordship,
you would require it for certain reasons. He will influence the witnesses.
correct, Lordship.
He will manipulate the documents. He will create chaos if he is allowed to discharge a duty. It will be an embarrassment to the university itself. There can be so many things. Ajay Tiwari also says that if you cannot put him in that particular department because he'll be an embarrassment or he will create a chaos. Put him wherever you can. Put him in the records.
That is,
But
that authority is the
50% of the substance allowance continuously. Not saying why. Not saying why.
Yes, correct.
Why should it not be 75? Why should it be retained at 50? You do not give a reason. Why he requires to be under suspension continued? You do not give a reason anywhere. Not even in your files.
Correct, lots of time. I cannot improve.
You have not given a reason in the affidavit in opposition. This is why it requires to be continued. You say it is continued by the proper authority?
Yes, sir.
Properly.
Not, sir.
The reason has to be there. That is what this court tries to find out.
Not, sir. Correct.
Now, if the reason is not decipherable anywhere, will it be a case where perhaps the suspension of continued suspension of the petitioner may not be done?
That I leave to appeal because I cannot.
Give to us all the.
No, I cannot.
We pass an order in
No, Lordship, I cannot improve the
We will
record.
simply record that this is the case. We do not find any reason. Mr. KL says it's upon us. We fail
No, Lordship,
to find a reason and therefore.
no, Lordship, I cannot improve the records. What is there, Lordship?
So that for that continued suspension,
Lordship,
something and without a reason for the continued.
no, Lordship, I cannot make any comment because I am assisting a Lordship. I am not, whatever is available in the record, I am.
That is where we feel good when we senior advocate side. We can,
No, Lordship, definitely I will not.
the pressure is not there. We can understand.
No, reasons are not there. It is admitted. Lordship, may I place judgment of Ajay Chaudhary?
Ajay Chaudhary, I was saying Ajay Tiwari.
Ajay
He's
Chaudhary.
an old friend. Ajay
Ajay
Tiwari is an old friend. Ajay Chaudhary.
Ajay Tiwari is the incumbent in this case also.
Uh-huh.
Ajita.
Ajita
He's one of the appointees who have been given in
Charge.
charge.
Okay.
And Lordship, further Lordship, post of dean is not a permanent post. And this is a
Even
substantive.
the registrar,
No, Lordship,
even the registrar is not, I think it is for 5 years.
yes, it's for 5 years.
It's not a
And Lordship,
permanent.
dean is a rotated.
HOD is not a permanent.
Yes.
Registrar is not a rotational.
No, register is not. It is a tenure post for 5 years.
Then you have to also address the argument
What's
that when the EC gives the power to the VC to do all matters which are required in the disciplinary proceedings, can he further delegate that power to the registrar?
that Lordship?
That you have to address us. You have to say yes or no.
No, Lordship.
Not today, not today. We'll keep it
I'll-
further.
I'll
We are not
make,
catching anybody out.
I'll make research on this point. I'll assist her.
Admitted position, it is the EC who have to do it because the first suspension is on the, by the EC,
By-
he is the appointing authority.
Yes, Lordship.
Immediate action, the first letter, if it had been issued by the vice chancellor saying that I think you should be suspended, good enough. But the stand is, EC told me to suspend and therefore I'm suspended. That is the flow which comes. Therefore, DC knows he is not authorized unless the EC does it.
Yes, Lord.
EC gives him the power. Now he gives it to someone else. Could he have done? DC can drop the charge sheet because of that 3-5,
Yes.
3-4.
Yes.
He has all the powers. So he can say, okay, registrar, please drop the charge sheet. I'll approve it. I don't have the power. He can delegate it. Please issue the order. I don't have the power. All these powers can be delegated. But the power which came to him from the EC,
You see,
he had
whether he,
delegated that.
whether he can delegate.
The extension part. Again, the order says competent authority hereby does it. Competent authority is the VC.
Competent of, yes, yes, Lord, correct.
Next line, he says competent authority is VC,
Yes,
not
correct.
me.
No, yes, he said
So he's not exercising the delegated power,
he's not accessing his power.
delegated power,
Yes.
but saying that hereby he is doing. Then he again assumes the role of a delegate.
His Lordship, it is admitted that he's exercising power as a delegate power by the VC.
Then he's saying that a competent authority is he and he hereby does it.
Yes, Lord. And Lordship not.
He does not say that being authorized by the VC,
Yes,
I deem it fit to extend it. No.
that is not correct.
And he does not even say, I deem it fit to extend it. He says the competent authority extends it, so it will be like this.
Yes, correct.
So what was the mind of the competent authority? Whosoever it be, the VC or the registrar or the EC, what was in the mind that it requires an extension?
Oh, that's it.
This is like rejecting a bail. You stay in custody. Is it not? Some application of mine, why I need you behind bars, why I need you out of the office.
Correct.
And that is what perhaps this Ajay Chaudhary case and all other cases have discussed. The necessity to suspend during a disciplinary proceeding cannot be doubted. There is a necessity. There may be a necessity.
Why?
What was the necessity?
Why?
What was the necessity? The documents are yours. The not handing over the charges, the time frame exceeding, the viva voce for the PhD, everything is in your records. Why does it need to be out of his salary?
That is a question of,
Because when already I am removed from those posts. In HOD, I no longer hold those posts. Those are separate offices. My reinstatement will be as a professor.
And this some documents have not been given handed over to us.
no,
Let us be Mr. Kel, let us be to some extent. I find this reasonable. Whenever someone joins an office or takes over a charge, seldom can it be the case that we will go to every document, make a list of it. This is what I have in my office. No one does. One piece of paper, I am handing over charge, all documents received, all materials received,
this
everything.
is a
Yes,
no,
yes, yes.
this is a
Now,
normal.
when he is asked to hand over the charge and someone stand up and say, he has not given me all the papers. First, tell us what are the papers.
Definitely, that is the point.
What are the papers he is not handing over? That plea is not anywhere.
That will be
That this particular file number 108, is not giving it to me.
probably in regulation, it has been mentioned.
So this delegate and delegation of delegated powers
That-
can be competent authority.
I'll come with
Thursday,
probably court is closed on Tuesday.
Tuesday,
Tuesday.
you can have it on Tuesday.
It's very cleverly counsel. It says non-handing over of charge, then in bracket. Non-handing of files and keys and some things. Well, the keys, I have made it very specific, these are in the office. I never have brought them. And you think that-
Seldom will a dean of school carry the office keys in his pocket.
Done with office stuff, my God.
It will be the keys to a safe locker if he's managing the accounts.
Probably this is a
So
point.
will he carry the keys of the doors? Dean of school.
No,
I mean, I'll show from documents they're functioning from the next day itself. And they're saying, well, the documents are not there,
So,
attending meetings, well,
the
taking
disciplinary
leave.
proceeding, if he requires documents, if they are in your hands. Once you hand them over, unless there's a malicing, allegation of malice, and you are unable to require. I don't think that a disciplinary proceeding can stop at this.
So what happened?
The taking away of the powers, head of the department is rotational, dean of school is rotational. These powers being taken off short before they actually the term is complete. There is a division bench judgment, if I'm not wrong, where the head of the department of mathematics was removed from a particular department. The division bench said nothing. It's a rotational post. We were not there. The term is not forgiven. So perhaps rotational part we will not like to interfere. The disciplinary proceeding will have a thorough look on. Suspension part, I don't find
Lordship,
the
actually,
requirement to keep him under continuous
to be very
suspension. I
frank,
don't find
Lordship, I am also
it.
but in favor of the extension.
Continued suspension, we are not.
So far, there's a removal part also, Miller.
Hmm.
I mean, those are totally stigmatic. I'll show.
No, the stigmatic part also. That is why we have indicated that there is a division bench judgment.
Yes, sir.
I was for the Dibrugarh University, if I'm not wrong. A.D. Chaudhary was there. And SK with his CGSE had moved the petition. Writ petition was dismissed. Writ appeal was dismissed. Maybe both of you assist them to find out that case. I forget the name.
I will also,
That case, the head of the department part was discussed by the division bench quite at length. Quite at length.
I'll know.
So whether the rotational post, whether needs to be retained by you, not retained by you, that.
I don't know. I don't know what was there, what are the case, but here is the case, not this matter, case. It was with imputation of misconduct. It was with clear imputation of misconduct. So therefore, Miller, I'll look into that.
Have a look at that
Ah,
case. Also.
that will- definitely.
If it says that this was a decision which does not require an interpretation, I do not know. That is why we want to keep it for Tuesday because things are coming to mind and we don't like to go through it. And
You know, say, Miller, only typically I have another part of method.
Thursday,
So, third.
Thursday, next week. Next week, Thursday.
you know, like,
Chat.
4 तारीख को नहीं,
Fine.
4 तारीख को हो गया।
No, no. I'm doing correct. Thursday. Civil case will be too.
Lordship, on fourth, Lordship,
Huh?
on fourth, I have some difficulty. I am going
No,
to,
we are not on fourth. Oh, fourth, you have some difficulty, na ninth.
I am going to Itanagar, Lordship.
On second, then lordship will the second, will accommodate it for some time. Another part.
Probably second will be,
On second, we keep it as and when you can come, because
Yeah,
mostly he has to address
Yes.
us
Lordship.
on that issue. Delegated and whether it requires a continued suspension or not. Even if at this stage. And that 91 days, we will also have to calculate that.
I'll
If it
calculate
goes
that.
in sub,
But regarding Lordship, my personal advice to the university, probably prolong the suspension.
it is not necessary in this case. Right,
I'll address your Lordship on second.
second, we'll have it on second part.
Other cases, best.
No, we are keeping all of them as part of, because we'll be deciding the suspension part first. Whether you are ready to participate in the disciplinary proceeding with a complete salary being on the job. What kind of duties they give you is secondary. This rotational part, we can decide if you come back with those judgments or if in MLS or something is so, but that is not very important whether you remain the dean of schools or not. What will remain is this disciplinary proceeding. Address us on the 7 or 8 grounds that we can interfere in a disciplinary proceeding.
Yes,
There are 7 or 8 grounds,
Yes.
not much.
Yes,
If one of them can be mediated to the extent that whatever documents you need, they give it to you within 15 days and you proceed. Well and good.
In fact, my lord, they provide us some of the law.
Ah.
What has happened here, my lord? The difficulty here is they made such literal allegations against us.
Hmm.
Let's say, my lord, two allegations at this time. Those, of course, first of all, it is not by the AC, ratified by the AC, then that's in the charge sheet. These two charges are with regard to hindering over of not finalizing the PhD for one working day. And another person, lady Ajita Tiwari. Now, my entire case is based on this factor. That these persons did not, when I was there, these persons were not qualified to hold this post. Or this, the situation has not ripened, so that these actions could be taken. There is a series of
That
correspondence.
is a matter to be placed before the discipline authority. We will look into it.
That is what I'm saying. There is a series of.
And this is a stage where you are yet to file your reply to the memorandum of charge. Sir.
Yes, exactly, because.
Now, if you file that reply and they do not consider it at all,
Yeah.
you may have a case to come back to
Yes.
say that it is a non-application of mine. But you're not replying to it.
No, the difficulty is that is on my case. That's why this on the state.
Hmm.
These documents are essential for my reply. Because what they're trying to say is you have not done this. I say that this could not be done for this reasons, and I had also done, given.
Your part.
Yes, I had done my part, because what had happened, this entire issue arose out of my doing my job properly with regard to the office of the liaison.
Your case basically is, instead of an inquiry, which would have given them the appropriate answers, they are holding a disciplinary proceeding, presuming that you have not.
yes.
That is, they are changing an inquiry into a disciplinary proceeding.
And those two charges, importantly, were not a part of the EC's resolution. EC never went into those charges. Because with regard to this non-handing over of keys and things, that is where Lordship has seen the EC's resolution. EC's resolution was with regard to the non-handing over keys. Those two charges have been brought in by the registrar of the DC on their own.
Now that we will look into the records, how those have come in.
Yeah.
That we'll look into. On Tuesday, we'll try to see if the suspension part can be solved, number one. And number two, whether a disciplinary proceeding requires further interference at this stage. Or can it be either closed or allowed to proceed?
Lots.
But you will have all the liberty, even if the repetition is not there. Petitioner will always be at liberty to come back as and when there is an injustice. That burden will, that entitlement will never be taken away.
What happens when your Lordship looks into the disciplinary proceeding? Lordships, the jurisdiction is quite circumscribed. Lordship will not go into many of the things for which will.
That is why we said those 7 or 8 grounds, just address us on that. Any one of it fits in. You score a home run.
So let's.
We'll have it on second.
Second.
We'll accommodate you.
If necessary, I'll take some.
Lots. Much.
Okay, list again on the 2nd of June as part of.
Seats.
This matter can be taken up sometime, my lord. Mr. Gogoi is on legs in port number 2, my lord. He
Ah.
requested for after some time.
Will not say at 2 because we do not know what will happen at 2. We let it be there. Have one of your councils here. One of you be here. If Mr. Gogoi is here, we'll take it up.
My lord, deeply approved.
Time being taken.
Last three occasions, last chances was granted to the elementary education department.
Hmm.
Their affidavit. Three occasions.
Yes, sir.
Also here, SCRT has already filed.
Uh-huh.
There the
That will
direction-
suffice? That will suffice?
Our instruction is awaited otherwise, and this is a, regarding the lecturer lawsuit.
Who appears for the SCRT?
SCRT already filed.
The teacher.
Have you seen the order dated 27/4/2026?
Lord, my learned friend was there and I also inquired. There was a direction to file affidavit from the SCRT as well as from the elementary education department, and our instruction is awaited.
You. Elementary education is required, higher education is not required.
No, elementary,
What is your case, sir?
The degree of master's in visual art.
Mhm.
Two advertisements were issued where for the post of lecturer in art education. And the minimum qualification required prescribed there is master's in fine art.
Hmm.
Our contention is that these two degrees are equivalent.
Hmm.
And we have placed certain documents also in our, along with our petition lordship. Before that, these two documents, these two degrees are equivalent and we should be allowed to participate in the selection procedure. Okay. To interim orders, we have also been allowed to appear for the interview.
You have appeared for the interviews. Why is the education department's affidavit necessary?
Lordship, because it is the elementary education department who has delegates the recruiting power to the APSC, and they say that it's this qualification has been provided. by
Department
the-
of Elementary Education, the Directorate of SCRT is also under the Department of Elementary Education.
Lordship, that is what.
The director has already filed their affidavit. We
Directly
do not know the
SCRT
stand of the government.
Lordship.
Are you authorized to file that affidavit on behalf of government also? No. What is your stand in the affidavit?
On the basis of an notification issued by the elementary education.
Problem.
We have given the.
Now, this qualification, is it equal or not? What do you say on that?
That we have to be cited by the education department.
And till now, the results have not been declared because of this litigation. 10,000 cost. You are having schools
Lordship.
or this post of what? Lecturer in the
Art education.
diet, in the diet.
Right,
Is it?
right.
District Institute of Education and Training.
Lordship.
You are keeping those posts vacant. The teachers are not there to give the lecture to the teachers who are teaching in the elementary education schools. Happily, you are saying that you do not have instructions. So cost of 10,000 for delaying the proceedings, not for filing the appeal. We will say that the elementary education department does not deem it fit
In fact, we have already.
to let the court know their stand in the matter. Therefore, we are closing all opportunities for dealing the matter for the last 3 years. Cost of rupees 10,000 to be paid. And it will be listed next court hearing. And since you do not say that this should be rejected, their degree should be rejected, we'll allow them to participate and they'll get their jobs. If they're meritorious enough for teachers.
My lord, we have already filed affidavit.
Are you saying that they're equal or not?
That is not the question here, man.
Sir,
APSC, whether is it, we are the liquidating agent, we are just, the advertisement as per the prescribe, we cannot go deviate from the advertisement. If they say that, yes, SSLC or equivalent, then no problem. But whether you want equivalent or exactly that, because it is a fine arts. So that is the question, madam. Whether you want, the government says that is equivalent also you can take, then we have to know the objection, madam. But we have to go by the advertisement. That is our case.
So it is there,
That is my lord.
that the delay on the part of the elementary education is
No, yes, if
the
they
only
say-
hurdle in finishing this case.
My lord. If they say that, man, yes, you can take the equivalent is also, you can take, then no problem, man. Some
They required a postgraduate degree in fine arts.
fine arts.
And you
but
have
they
a
are
postgraduate
visual art.
degree in?
Visual art.
How do you say they're equivalent?
Lordship, the UGC regulations that prescribe the teachers who must, who would, the UGC now calls it as visual arts itself. Lordship. Earlier it used to be fine arts. In fact, the APSC had earlier issued certain advertisements where the terminology was used as fine arts, but then I had participated, I was allowed to participate in the selection procedure. Lordship.
Where is that UGC part that you say is, are you prepared for today or?
I can briefly show, however, I'm led by Mr. S. Gauhati.
Just show us where they have got this fine arts and the visual arts interchanged.
Page number 78 is the net syllabus for visual arts.
Page number?
78, Lordship. The first 4 lines of each letter.
I'll just come back in 2 minutes, huh? You also try to go through the pages, show us how they are interchangeable, or yesterday an interesting argument was made in this court saying that being part of the subject may not be the subject itself. Right, in some computer, this thing, mathematics is a part.
My lord.
They wanted a master's in that computer subject. He was a master's in mathematics. Supreme Court has said no. Even if mathematics is a part, you don't fall in there. I'll be back in.
My lord.
Otherwise, for delaying the adjudication of the matter only because you did not file an affidavit,
Only in regard to the petition.
the order will contain costs. Tomorrow, list tomorrow. Make a mention. In one matter, Mr. S. Bonik is appearing. Go through the list, find out that matter. Be here. Yesterday's matter, yes. Here is a better case. They say it is the same. UGC and the other councils also. Everybody says fine arts and visual arts is the same thing. So simply because the certificate says that they are not. The certificate says BVA, therefore.
But even then, my lord, suppose nobody dispute, my lord, if he is the same, even if it is the same, then my lord, APC cannot allow him until and unless government clarify that it's a letter that he can take it, because.
Or
because
this
of that-
this code clarifies that you can accept it.
No, because what happened, my lord? Because of the advertisement of some, those who are VMF, my lord, they have not applied. No, that's why once for all, my lord, government has to clarify it.
Those who do not try are not fair.
Exactly, man. But your lordship kindly, that from the government at least once for all in future also, my lord. That's why they will clarify it. That's why affidavit, why I am submitting, my lord. Tomorrow again the same problem will arise, my lord. It is not the
yes.
last several occasions we are facing the same problem. And already everybody reviewed the APSC because it is not an advertisement of the APSC, my lord.
No, you are
Everybody says that FEPC advertise sometimes FPPS, but it is not our advertisement.
whatever is the requisition is what you advertise.
My lord. So
We
we
take
have to
that-
go by the advertisement.
We will take that into account.
My lord.
We'll take that into account tomorrow
My lord.
if you are available. So. Yes, item 9.
My lord, I am appearing for respond number 1, but my
Yes,
lord, the education department has filed their affidavit. I think that will cover our stand, my lord, that we have already sent this proposal for compliance. And lordship takes up the affidavit filed with the education department as at page 52, my lord. The stand taken by the department.
What was the claim?
My lord, it was under the, there was a direction by the honorable court for for appointment in grade 3 and grade 4 post with persons with disabilities. Now, lordship may kindly come to page 51, my lord. At the bottom, it starts paragraph 6. That in compliance to the order of the Honorable High Court in WPC number so and so, the office of the answering deponent, that is the education department, conducted a discussion with the Department of Social Justice Empowerment on 17/10/25 regarding the accommodation of the petitioner, Srimati Rangjali Basumatari, in grade 4 post. It was decided that Department of Social Justice and Empowerment would re-verify the list of selected
Who
candidates.
appears for the director? Yes, sir, tell us what steps the director has taken.
Lordship, here also I have received the instruction.
Ah.
I have received instruction, telephonic instruction, Lordship, as per the instruction, Lordship. The proposal has been sent to the government.
When?
It was on, and there were certain clarifications also, that clarifications were clarified on, Lordship, I will just put the exact date, Lordship. In, it was sent on February 26, but thereafter, in this regard, the government has requested to furnish the relevant records pertaining to the original sanction and number and permanent retention number in reference to the formal.
That has come to the?
Accordingly,
Ah.
Lordship, accordingly, as per records received from the DO of Bongaigaon,
Hmm.
this directorate has submitted the required documents to the government by this office letter number so and so 29/4/2026.
29/4/2026.
For
Yes.
further necessary action. As such, it is stated that after getting the necessary approval from the government, the appointment of the petitioner will be made in compliance of the order dated 4/2/2026. WPC number 6160/2023. Therefore, the proposal has already been sent to the government with some further clarification also.
Seeking?
Further clarification also that has been submitted to the government.
When?
29/4/2026.
So when will you have the
Last
next?
month.
Now you will send it to the finance.
Lordship.
Now the government is required to send it to the finance.
Lordship.
What is the stand of the government? That is by the director.
Lordship.
That is by the director
Secretary.
to the secretary.
To the secretary.
You have sent it to the secretary.
Lordship.
F2 have information what has been done.
Yeah.
F2.
Lordship.
Hmm?
Lordship.
29/4
29/4.
and we are nearing 29/5.
Lordship. Today is 20.
What has been done? F2.
Lordship.
F2. Yes, sir.
Regarding the headmaster C of High School.
Hmm.
Whatever was the commissioner was the founder teacher of High School in 1995. He was appointed by the meeting committee, approved by the schools. Then the very good. When he continued marrying 2013, his services were utilized. He comes of the 2011 promotional terms. Act. That however went down the lane, my lord, in 2016 by the
judgment of the school, which was struck down.
Hmm.
Anyway. But
The provincialization remains.
Yes. Hello?
Provincialization is in. Ah.
Thing is not struck.
Hmm.
So in the review order also. Some words.
Ah.
Then my lord, the private respondent, Mr. Thakur, comes and transfer from Yakaduli, Manu Kumar, any school to Krishna district,
To your school.
not to my, to any school,
Ah.
not to high school, in the ME school category. In 2015.
Hmm.
Then my lord, the school of the private respondent, the ME school, gets merged or amalgamated with my high school
Hmm.
in 2017. Then he was a part of the high school teacher.
High school.
So long he was ME school teacher. Now he belongs to senior because he was appointed regularly in ME school in 1996.
Hmm.
So 5 years going that way. That he was regularly appointed, whereas that was appointed in the Bethel states. The Bethel states continued till 2013, 1st of January 2013. So, if his service is counted in the ME school, then
He is senior to you.
but if my service counted from 2013 onwards,
Hmm.
forgetting the last part of health stage, then I'll explain in the high school cabinet.
Ah.
That is the issue.
Because his seniority in the high school would start from the date of amalgamation. Okay.
2017. But there was some manipulation of records pilot at the level of even extra school pilot, that was later on when pointed out by Prohibitions, that is corrected. Because once you are shown to be regularly appointed in the executive author, ME school itself. It was not correct.
Ah.
Now my question is, exactly, sir.
Hmm.
The private respondent, but Thakur got pilot BA degree in 2022.
Hmm.
Few months later, I got in 2023. So, the earlier man retired. On his retirement, Thakur came to school. Another man was shot to the degree. He came to school and got an order to the director. I came to the director to judge the qualification, according to rules and give reduction.
Ah.
Exactly. Materially, he continued to be in charge from 1/12/2022. Once I completed my PhD degree in 2020, then I started claiming to be in charge headmaster.
Hmm.
I filed the application to the director also, but they were not responded to. Then I completed the course in 2023
Hmm.
by this 7.41 of 2020. And now it's pending. Now, the position question, the restrictive question to be decided is whether who would be senior in the high school. Because there will also finally come to, first we will also go to 1977 Act. Because the 2016 rules.
Hmm.
It was must to constructed the directed on the basis of 2097, right? In my opinion,
Page 293.
it, technically. Nice. This is still alive minor. So many laws have been 2011 and 2017 in past, but this act is not yet been. It's still alive and still. In Russian mind, because why I want to refer to the this act is that in Russian mind, section 2, 12.
2,
12.
2
12.
of the
77 Act.
77 Act.
Yeah.
What is the full name of the Act?
Hello?
Full name of the Act?
Name of the act. Elementary education provision act, 1977. Fifteen of 1974.
You are on the rules.
Rules. 293, next page is 294.
Hmm.
Rule 212. Upper primary school means institution from imparting education up to class 8. Including any school or any madrasa or senior basic school. It usually are the combination of any of the three or all of four at the beginning of this.
Yes.
So he was the upper primary, imparting up to class 8. I am in the high school. We were at class 8. So my simple submission is that this student is here to me, having joined the high school in 2017 by virtue of or by dint of mother. If that is so much, then I will be entitled to be in charge of the school. This is my short submission. Now I also going to come to 2018.
Page 18. Judge, it must.
One. Section 3. These rules will apply to the union for what in the senior secondary school and secondary school, after my madrasa, high school, which is been recognized under the Assam Secondary Education Professionalization Act 1973. Assam, I think this is so, my lord, is that this will depend on the seventy of the area. Now you're trying to come to become free. You need a high school. You do. High school means high school includes madrasa, imparting education at the class 10. This another category Assam secondary education, promotional at 1947 or any other registration collected by the state government. Now, when lots of time come, he would. For in this category, rule 3, gatherings defined according to qualification of post health matter. Not again.
Yes, sir.
Rule 3, 323. In service in a provincial school, the concept of following
If you want to put reserve using three, the stop shall consist of the following classes and cadres. Each of one of these constitutes distinct and separate cadre based on the commitment of the students, namely class one says include the cadre of principal, two include the cadre of vice principal, post unit teacher, and headmaster, register of our high school, and superintendent. Class three includes the cadre of assistant headmaster, assistant superintendent, and the graduate teacher. Then nothing kindly come to put three. 35.
35 years.
Most of the remarks of a high school, and school of high madrasa, they will build up the common, the promotion from the members among the graduate teachers, expert district-wise community, which on the attendance of the district selection committee constituted under rule 16P. The selection of the headmaster shall be upon preliminary and sensitively annual comparison report and the last two consecutive years. As for procedure provided under summary 3. However, seriously of the graduate teachers shall be defeated for the period of institute graduate skill of pay by the respective assistant teacher. Now, these were some of the then not in my come to graduate teachers. Anything for the course in market. Some other BSc become a BA. Now you are to come to 24.
24.
Yes, please, 41. If there is a member with cadre, now it is it's a cadre. It is not which cadre, any school cadre, high school cadre, same cadre. Unicorn cadre. If there is a member of any cadre, appointed by direct influence shall be delayed to the order of events in the respective select list. Finally approved under rule 8(2), in respect of postgraduate teacher or graduate teacher. If he joins the appointment within 15 days, because he has no citizen as such. They can receive the order of appointment within the central. He should not apply because I was in graduate school, we came from middle school, on class one, we came. Then also when you come to trouble 3, the senior member of the service in the cadre who otherwise come by direct engineer. If on transfer or otherwise shall be delayed. If for the date of joining the still become constant cadre. If a member joins into school or transfer from school of another district, the seniority shall be between from the date of joining in the concerned cadre and the seniority of the other school of other district or even the same school in a different cadre. They will be present into the fund.
Shall not be.
It is what like this. Am I clear? Now, mother, 25. Problem 2. Get us a list. The general list in respect of post in the cadre of this that of teacher shall be prepared and published will be by the appointing or fee every year containing the name of the members of the service cadre. Yeah, service cadre for all the schools. In order of seniority and such other particulars is the date for Date of joining is present status. That has been service from service community to which we have justice.
Then they got to publish it.
Yes.
If they don't publish it, then they will publish a final, final list. Huh.
Yeah, one character is final.
Huh.
Where I was told senior, junior, he was junior
Huh.
in one. And another, this one, and you was on senior, I was on junior.
Mm.
It was my, he senior was from 1996, I was from 2013.
Have you challenged that list?
Pardon?
Have you challenged that list?
I will ask to file, compulsion with file. No offer. But the date of my appointment is shown as 1995 in the list. How about the subgroup four? The graph, common medical teacher, and postgraduate teacher, higher secondary school, monthly school, 70/40, things for the higher secondary highlights. Now, we also learn about the CD, pay, CD one. Pay is 48.
Hmm.
Over this one will gain about 50,000 to 49,000.
Graduate teacher, yes. Huh.
So, but next one, sir, we are in the same.
Yes, you're in the same.
We saw the same.
Hmm.
This, that is the on the pivot point. Now we'll also find the HCL. The next step is the segment in my appointment in high school on 15/2/1995. Then the next step is the appointment of uniform portable for private student in any school in deputy on 30th of September 1996. Then minus 2000. Let's say C and also one C is 22.
Page number?
Is 22 minus.
Huh?
22.
22.
In the element of plus to getting for the high school.
Hmm.
After formulation, the teacher, that was 2011 X. My school is recognized the 1/1/1995 and my formulation show 1/1/2013. Teacher.
Yes.
Most I will only tell that. In this manner, Mr. Bhattapur was not there. And manner, Anupam Bhattapur comes and transfer from Kaduri minor from Sonipur to Krishna district semi school on 30th of December 2015. That is annexed. He get this 24.
Wow. What does this mean? This sentence?
Hello?
On the ground of their prayer for transfer? At page 24?
Yes. In person to the official memorandum,
They made a prayer for transfer.
I'm not sure, Malam, but pay in school cited below on the ground of their prayer for transfer to maybe
Ah.
school,
They chose the school.
maybe,
They were said that you will be transferred, choose your school.
maybe, my lord.
No, my lord. Full. On the prayer of for transfer to. Previous right to redemption was 99.
Hmm.
It was on his request, he was sent to from yellow KD, India any school to Dadagiri to Reading any school in Gujarat.
Hmm.
So if he returns the request manner, then it's a good 24 manner.
Nah, he's goes. He loses seniority, yes.
Yes, he needs anything and he will get from 2017 only.
Yes, sir, you are a teacher of the ME school.
Yes.
Initially, I was
Then when did you start drawing your graduate scale of pay?
from the day one. As
In the ME school?
Yes, I was.
Or you are a science teacher, so
Yes.
you have a graduate scale of pay. Okay. The seniority will be as per the graduate scale of pay.
Yes. That says,
Amalgamated school.
no, not the rule
Eh?
14 says, my lord,
Rule?
14, 1 4 of 2022. Uniform,
Whenever he came to that school, we are not concerned by transfer.
Yes.
You would kindly address us on this part.
Rule 24, 5 minutes.
Hmm?
Rule 24, sub rule 5.
first will also go to
The beauty of this book,
Page 42, my lord.
huh?
Page 42.
The beauty of this book is when you want to open one page, all the other pages run out, leaving you only with one page. Page 42.
42.
Page 42. No, even on this page, if we don't go, let us have that headmaster part again.
Then page, my lord,
36.
35.
No, page 36. Page 35. Okay. Provided that graduate teacher shall include the cadre of assistant headmaster for the purpose of selection to the post of headmaster, and seniority of the assistant headmaster shall be counted from the day of joining as graduate teacher. And you were showing us this one. Proviso.
Yes.
Provided that in case of graduate teachers, the seniority shall be counted from the date of getting salaries meant for a graduate teacher.
Yes.
And in the school itself, it will be as per the date of joining in that school.
Yes.
And in the district, it will be per the date of drawing of graduate scale of pay. Is that how we understand it?
Yes, madam.
How should we understand it?
Here, provided graduate teachers shall include the cadre of so and so purpose of selection to the post of headmaster, and the seniority of the assistant headmaster shall be counted from date of joining as graduate teacher with graduate scale of pay.
Yeah, he's not a contractual teacher. The professor is just above it. 24/5. What does 24/5 say?
24/5.
In case of amalgamation of any school with high school, the employees of the amalgamated school shall be given seniority with effect from the date of joining on substantive appointment or
Or
regularization. That means for him, what will be the date of?
From date of initial date of joining, if he has joined in the substantive post, my lord, from that
Substantive post of what? In the amalgamated school or in the earlier ME school? Or in the
original
school,
school, in the
original school?
original school, my lord,
He will get his seniority
Yes, madam.
from that day
from the dead day.
in case of amalgamation.
Amal-
So if there is a graduate teacher in the
ME school.
ME school and there is a graduate teacher in the high school who had joined services later,
Yes.
according to this,
Yes.
the person who joined the ME
ME
school as a graduate teacher will gain seniority over the person in the
Yes.
high school.
Yes, madam.
And even otherwise, from the date of graduate skill, from when he was joined the graduate teacher salary,
Yes.
it will remain there.
Yes, madam.
So a person in the high school who who did not draw graduate scale of pay at an earlier point of time for whatever reason, he loses the seniority.
Yes, fine.
Yes, sir.
That is one point, which they were, that's why I have told your lordship earlier.
True.
We put it
Huh.
to the issue.
Huh.
And so far as far as the rule. We is concerned, Madam, that. Transfer and his own request.
We do not know transfer on his own request. From where?
Hello?
Where do we find that the transfer is on his own request?
There was the matter. The swell some of schools. In there. We claim to be transferred to Snap.
How do we know?
Hello?
From where we know that?
On the transfer order, madam.
Where is the transfer order?
Transfer order is my lord, 224.
This part you have to clarify. What do you say on this?
My lord, this is a common transfer order around the, my lord.
So be it, but that
Around-
sentence on the
around-
ground of their prayer for transfer.
Yes, yes, there is no prayer for transfer. It is there, rather it is clarified by the, my lord, at page 99, in my affidavit, I have the letter. As the common transfer order, there is no ground for my lord, own disbursement. It is clarified in page 99.
Next one, my lord. Particularly, there was the, motion for restoration of teachers. Was there a few teachers, my lord, so access to transfer. And in that matter, many teachers made request transfer to respective places.
Hmm.
So he chose, because he belongs to Kusha district, he chose to,
The transfer was not on his request.
madam,
The place of posting was. Transfer was not on his request.
this was part of the school to make.
Transfer, he had to go out of the school on any case. They just gave him a choice. Name the place. So is it a transfer on request?
That point is not clear, madam.
No, it is clear at page 99, it is clear.
99.
And you have not challenged the final gradation list which has been published.
The next in the additional category.
Hmm?
The next is gradation 11 portion, gradation week, the additional.
Is that actually?
No, that is.
I don't know.
Yes, sir. Now, this science graduate teacher inclusion was out of some order of the court. Why science teachers are not being considered for? Is it?
Rule challenges, my lord.
There was a rule challenge and science graduate teachers were required to be included,
It's,
not included for a long time.
yes,
Huh?
and therefore there was an amendment.
Yes.
In fact, the amendment is also under challenge, my lord.
Huh?
Amendment is under challenge, my lord. Subsequent amendment.
This is challenged by the arts graduate teachers, those who are not given the graduate scale of pay, they have to challenge in separate posts.
What do you mean by an arts graduate teacher?
Arts graduate-
There was only one batch of art graduate teacher. There were only some few numbers.
Yes.
Anybody having a graduate? Yes, sir.
Graduate teacher includes all section of teacher, madam, other arts, science and commerce.
No. Graduate teachers include, as per the decision of this court, graduate teachers include only those teachers who were required to have graduation as a degree to
Yes.
come into service. Anybody who has a graduation in the,
Because in any school, one may be.
only one science graduate teacher was there. No other graduate teacher was there is the decision of this court. We cannot help it.
No, my lord, science get, until my lord 2000. Five, I think. In any school, science teacher was up to higher secondary. Let me come out on any day, I will clarify that point, very important point. To the higher secondary only. Graduate teacher not required. In I think 2005, once the NCT regulation came to be implemented. Then, my lord, it is made compulsory.
Science graduate teacher was part of his scheme.
Yes,
Science and maths.
earlier it was not.
And thereafter, I think there was some other subject. Anyway, so now, we do not find much merit in this petition. What to do? The rules say that the seniority has to be counted for an ME or MB school teacher from the date of receipt of graduate scale of pay.
Yes.
So then he comes in. His date is prior to yours for receiving the graduate scale of pay.
Sanctioning of the graduate scale of pay
Uh,
to the ME school science teacher, why it can be effective?
from the date of his joining.
No. Then at that time, 96, I think, so far I know, if I go to the other rules, it was not required. It is only under graduation. Or science. One may have graduation degree.
That is true. Where is that rule, 2000? ME school, 2000? No, 77 rules, which page?
290, 293, madam. 293.
Ah. Yes. You were appointed when? 90? 96. 96, it was matriculation shall be the minimum qualification for post of teacher in elementary school. 2005, it was introduced that you would be taken up as a science graduate teacher. What post were you appointed to? Where is your appointment letter? Where is your appointment
In the
letter?
1901, my lord, this scheme was introduced, my lord, by the government. For all upper primary school, there should be minimum one science graduate teacher.
Huh.
As a result, throughout the state of Assam,
That scheme is on record.
the scheme is in the department, my lord, the right.
Where is your appointment
Page
letter?
20, madam.
Appointment letter.
Yes, ma'am.
His appointment letter.
Yes, ma'am.
Page 21.
With type copy at page 20.
Let us. Page 2. Graduate science teacher. He's appointed as a graduate science teacher. So that is put to rest. He was appointed as a graduate teacher. Whatever be the rules, but he was appointed as a graduate science teacher.
Now, even the page 99 also says, my lord, last line. I'd like to include that any prayer petition, application for transfer, campus number
Is not traceable.
not found in the office record.
Huh.
Because there was a prayer, but it was not traceable in the record.
No. We would find it difficult to read it in that manner, sir.
Yes.
We would read it as there is no prayer petition on record. Is it?
Yes, ma'am. And it's not a request for transfer, madam.
The transfer, no, even if we say that there was a prayer petition, it could have been, please post me to so and so
Exactly,
school.
madam.
It cannot be to, please consider my transfer out of this school to that school on my convenience.
And transfer what?
There was a process of rationalization. In the process of rationalization, people were asked if you'd like to go and join in a particular school. They were all transferred out. The transfer had to take place. If they gave a choice, it was considered. If they were not given a choice, they were not considered. They were posted wherever they wanted to go. Maybe he chose a school. But would that take away his seniority? It will not. Yes, we'll dispose this, sir. Heard Mr. R.P. Sharma, learned counsel. Yes.
Now the 4 years, the error is going on.
What is going on?
4 years since 2020, 2021,
Ah,
5 years. So how long this review can be?
this in charge thing. Division benches ask them to fill up all the posts. They are not listening.
Tomorrow,
What to do?
because not both are qualified. Both
We will say we do not find any error in this order which you have challenged, and we'll indicate that they should fill it up by regular headmasters. Sooner the better. We will not give any time frame. We do not know on what time frame they can have a selection process conducted. Because they'll make an advertisement, they'll call for all the documents, then there'll be objections, then there'll be litigation, then there'll be so many and so forth. And it is from the district that the headmasters have to be appointed. From the district gradation list.
District has to be.
The district gradation list has to come up.
No, district administration is come.
Ah.
Now they have to initiate the process district wise.
Yes, why this in charge business continues?
No, the entire agreement system is not to talk to them.
Huh? All right, sir, we'll dispose this. We'll take it as disposed. The repetition will be, how do we say it? We will not find any merit on the proposal of the petitioner that he should be placed senior to the respondent, and therefore the order does not require any interference at our side. Yes, yes. Yes, we'll do that. But to save some time, we will not dictate the order now. You'll have it tomorrow. We'll do it tomorrow. Tomorrow you'll have the order. Disposed, huh? Disposed. What about the IA?
Now, since the mayor will tell me this order, I will do it.
Okay, IA and WPC both disposed, huh? Yes.
Only that one of the three expedite the process of selection. Yes, sir.
We will indicate.
Yes.
On last occasion, the Lordship directed me to have inspection.
Hmm.
On that list, my lord, that which has been annexed in the repetition.
You have to refresh us a bit. We have not exactly gone through this.
My lord. There are two different.
On transfer, he lost his seniority, something like that.
No. Right, it's regarding my lord, promotion.
And giving financial benefit to the person was promoted directly.
Well, the petitioner, he retired in 2009 as superintendent. One of his junior colleagues, he was promoted to the post of under secretary from the post of superintendent way back in 24/9/2007. Petitioner now wants that, my lord, he should be given the benefit to the higher post from that particular day. Now, my lord, this, my lord, incumbent who is junior to the lead petitioner, he was initially promoted to the post of, my lord, UDA prior to the, my lord, petitioner, following a gradation list, my lord. That gradation list was put to silence before the Assam Administrative Tribunal. Tribunal interfered with that gradation list of 2002. And, my lord, directed to, my lord, publish a gradation list by reshuffling, my lord, following the seniority. That was exercise. And that gradation list finally came into being in 2013. In the meantime, present petitioner retired as superintendent. From UDA, he got the promotion, but he was supposed to get the promotion to the post of under secretary. But before that, he retired. Now, my lord, following that order of the, my lord, Assam Revenue Board, some benefits have been granted.
On the persons who are still serving.
Yes.
But not the persons who...
by creating supernumerary post. Now, Lordship will see page 100, my lord. On last occasion, my friend, my lord, this particular document, whereby, my lord, the sanction, it says that with the sanction of the governor for extending financial benefit, page 100, on retrospective promotion to Sakradhar Kalida. He was the main first petitioner in that, my lord, petition appealed before the tribunal.
and other superintendents, or we will see the post is superintendent,
Hmm.
as mentioned in the enclosed statement for the period of benefit as stated against each of their names in relaxation of so and so, FR so and so. The here the name of the petitioner appears. This is a document of 2013.
Now, where does it appear?
His name appears as serial number 84, page
80.
106.
Povitra Mohan Deka, yes.
Lordship will see, my lord, the columns here. First column, my lord, is the name of the senior,
Name of the junior,
then
Huh.
name of the junior, that is Konok Sen Deka, and it is similar, my lord, in all the cases.
all yes.
Then actual date of junior of senior. I don't know.
The actual date of joining of senior.
Joining of senior.
When did he join?
Yes, then my lord, actual date of joining of junior. So 5/5/2003, my lord, the junior has joined
Yeah.
in the post of superintendent.
Hmm.
So, my lord, that benefit was given to all, my lord, from
Hmm.
this particular date.
Hmm.
Now, in case of the present petitioner, page 106, serial number 84.
Hmm.
So, from 5/5/2003 to 4/9/2006, that benefit has been given.
Yes, because his junior joined on 5503
Yes.
and he actually joined on 4906.
Yes. So,
Thereafter, he has got whatever salary he had to
He
get
is
as a
getting.
super,
so that part, that benefit, my lord, he has got.
you have got this benefit from 55/2003 to 49/2006.
Promotion relation for superintendent is concerned. I have no clue.
Hmm.
So far, my grievance is concerned, it is connected with the undersea.
And now from, just a minute. So this has been, you have got this benefit. Now what do you want?
I don't, the benefit which has been extended, similarly, in relation to the post of undersea.
But you have retired prior to becoming an undersecretary.
That's true, madam. So far, the financial benefit has been given to the persons. Some of those are retired prior to my retirement. But he has received the financial.
Give us one example.
For example, my, let's see, we take note of my additional activity.
Huh? Additional affidavit, yes.
Page 246.
Page 247.
Okay.
47, yes. 47.
10 and 11.
Hmm?
Period number 10 and 11.
Hmm.
Sri Jabbar Ali and Sri Virendra Babu. They retired, Jabbar Ali retired on 30/11/2008. And Virendra Babu retired on 31/12/2008. And I retired on 28/2/2009.
As?
Superintendent.
No, as what?
Superintendent.
As superintendent. And these people retired as what?
Superintendent, they have been given the financial benefit of undersecretary. In view of my.
Lordship will see page 246, the
Yes.
main page, my lord.
Huh?
Again, Lordship will see the, my lord, columns. Name of the senior, name of the junior, actual date of joining of the senior as under secretary. Lordship will kindly mark
And
this.
they
my lord.
joined, they
Yeah,
retired
that's
as
why
under
Lordship will see
secretary.
now, my lord, in the next page 47, 247. Serial number 10, joined as under secretary if this particular chart is correct. On 6/2/2008. And
Did
the
you join
junior,
as an under secretary?
yes, for that period, that benefit has been given, my lord, under secretary. Actual date of joining has been mentioned, my lord.
That part is mentioned.
No. That retirement part, my lord, is not this, my lord.
So you never got the chance to join as an under secretary? Yes or no, sir? You did not get the chance to join as an under secretary.
Yes.
So your first grievance is that you should have been allowed to join as an under secretary. Before, who, out of these people, these 15 people, who is your junior? Anybody who was junior to you? All of them.
All of them.
All of them are junior to you. Have you raised a grievance that you were not allowed to join as an under secretary?
And the procedure for promoting the people under secretary, that was, what happened, madam, that was in relation to, madam, the promotion of the, earlier, madam, incumbent on auction data. In relation to this promotion, madam, some of those person was
senior to connection that are well promoted,
Hmm.
but that perspective.
Hmm.
Out of that person's model, the Jabbar Ali and Zain Kapoor is here.
Who were already senior to Connoxen.
Senior.
You
I am,
your case was not considered.
my case was not considered.
Have you raised a grievance on that?
Yes, that is why Madam.
That you should have been given a promotion prior to Jabbar Ali and Virendra Patwari having not given?
Not only I, Madam, not only 109% grievances.
Where?
Here, before the authority, Madam, and subsequently what happened, Madam, my representation was rejected. That is why I am before you laws.
Your representation was rejected for the payment of that retrospective benefit. You do not stand on an equal footing with these persons because they were already promoted. They had joined as under secretary. You never had the opportunity to join.
But that part is concerned. For the persons, I have my effort. For the way I was point. At the relevant time on they given also giving their taking care of the according to them. Giving those part of including mine. Here from what happened on 5 to 7, one of the under. Accordingly, immediately thereafter, become the office concern to speak and to promote art in relation to the one of the that are confirmed. Accordingly, our case has been under 26 for the office. Subsequently, when my case has not been disposed of, I thought if there are some that have been rejected. Because I am not answered to the.
When did you retire? When did you retire? Your date of retirement?
28/2/2009. And till that day, my lord, no representation was submitted before the authority claiming that, my lord. In 2017, for the first time, he submitted a representation. That was disposed of now. I retired in 9.
You never asked for your promotion to the post of under secretary. And out of the 109, only 15 people were granted the benefit. Others have not granted the benefit. Others similarly situated when they are not granted the benefit. You were given that. We'll come back at 2. We'll come back at 2. Otherwise, if you're never an undersecretary, how do you get the post? How do you get, unless you get a retrospective promotion or a notional promotion to the post of undersecretary prior to your retirement, how can you return? Think it over. Think it over. When were the persons junior to you promoted? No, to the post of undersecretary. They were all promoted on 5/10/2007.
Accordingly,
Do you not think it is unfair, Mr. Gogoi? He lost the opportunity to be promoted because the representation was kept pending.
Well, that is what part of the expedition. Neither he has made any statement in the
paragraph 9.
What does paragraph 9 say?
no date has been given when he has submitted.
For a time, he assumed that
that the government will access the financial benefit into the future also. Hereafter, my lord, the government has also said that if we access financial benefit, the proof of under. Accordingly, subsequent is that meanwhile, it has not been considered when they are approached, 9 or then my it has been taken up and that has been used.
In 13, you had already taken. Why don't we,
Lordship will leave my lord para 10 also.
if we direct you to consider whether he would have been entitled to the post of a superintendent because his juniors have been afforded. And in case he's found that, in case it is found that he was entitled to a promotion, then he'd be entitled to a relief granted to his juniors.
But
Because specific step. Because specific step. Because it cannot be a case that his juniors had been promoted after considering and rejecting. Apparently, there was a big mess inside the department. Some got it, some did not got it. People were raising grievances and they were not attended to.
no, what has happened is that on 24 entire mallet issue was came dropped in mallet because of the promotion of Konok Senteka to the post of Under Secretary on 24/9/2007. 24/9/2007. Mallet. Now, mallet, the order judgment of the mallet Assam Administrative Tribunal. It was disposed of on 13/6/2007.
No.
Before that, mallet, gradation list of 2000 of UDA would be mallet reshuffled according to seniority or recasted.
It was the ATA order was in
On mallet 13/3/2007.
17, yes. So in
2007, challenging the.
7.
Yes.
So,
Challenging the gradation
no,
list of.
giving benefit of the
No,
recast that was
that's what I'm
done.
saying. Lordship will see, my lord, the gradation list was of 13/2/2012/2002 or regarding UDA, not to the post of Under Secretary or to the superintendent. So that was acted upon. Direction was that, my lord, this list of UDA should be recasted according to seniority.
So that was done and a benefit was given by the order dated 31st of July 2030.
I think. My lord,
Yes,
during his
because
service period.
he had been ranked senior to the this
Yes, in UDA.
in UDA. Now, because of this recasting, because of giving him the benefit of being promoted to the post of notionally promoted to the post of the superintendent,
Yes,
by the order dated 31st of July 13, his seniority in the gradation list of superintendent would change.
Yes, sir.
Now, just because there is no order of the ATA, you could not have ignored it. Naturally, you have not ignored. You have given it to persons who were promoted as superintendent.
Lordship.
Now, while promoting those superintendents, you did not take into consideration his case.
No, in between, my lord, there was no promotion of superintendent. If you can show that, my lord, from 2007, when the judgment came into force or it was delivered, whether in.
He said that the juniors were promoted
Let me
when
show, my lord, who were the juniors who have been promoted to the post of
serial number 10. Additional affidavit serial number, something he was showing.
No. That's I have shown, my lord, when he was promoted.
That is what I'm saying. This page number 246. This page number 246, he says that this serial number 10 and 11, these were persons who were junior to him.
My lord.
These were persons who were junior to him but were afforded the promotion to superintendent, leaving him up. That is what you have said, sir? No.
That is not other juniors are not there. Now also they are there.
You forget that case.
Then in
There was an order of 2007 which required a recast of the seniority list of the in the grade of what was the first grade? UDA. That being done, you were already promoted to the post of superintendent by then when the order came. Since Connoxen got a promotion prior to when you were given the promotion, they gave you a benefit by the order dated 31st of July 2030. Yes? Since Connoxen Toka had got it prior to you being a junior, you were given the benefit by the order of 31st July 2013, correct? At that point of time, you were an office superintendent. You had other junior people below you, above Connoxen data, who were also functioning as office because you were already serving as an office superintendent when you retired. Prior to your retirement in 2009, this person at page 247, the persons who were there in page 246, who you say have been given the benefit of undersecretary. These persons, they were promoted on 4/2/2008. Yes, the top one of them. At that point of time, you were in service.
Yes.
This Ananta Khonikar, is he senior or junior to you? He is junior to you. So he was given a promotion overlooking you because he was given the promotion in 2008. You retired in 2009. Now, when he was given the promotion in 2008, did you say that I am also required to be promoted to the post of undersecretary? Number one. You were not promoted to the post of undersecretary in the year 2008 when your junior was promoted. Why?
Promoted in the year.
Yes.
When was promoted.
Yes.
So undersecretary.
Uh,
Not only I, the other part also
yes.
that has been processed together.
Yes.
If the department has been sent off.
Okay.
Applicant gets given. The government has decided.
On 9th of October 2019, this page 246,
Applicant
they have been given.
Yeah.
Now, this shows that this man, Ananta Panikar, was promoted as undersecretary on 4/2/2008. You were never promoted to the post of undersecretary.
I was, right.
So now this Ananta Panikar, you say is junior to you? We will try for 2 more minutes to find the answer from you. Otherwise, we are dropping it. Yes, we'll give you double of what you have asked. You asked 1 minute, I'll give you 2 minutes.
What if I don't when the these might have paid, they should by complaint. What if I after the contribution by the under my name was not the delegate, but I was not in plan. Accordingly, my on my application, I just identified on the party and according to my phone by the offered by the 7/8/2008. Now, page number 220.
Page number 223 is some gradation list of undersecretary in the secretarial service. Are you referring to that? Is it the gradation list you are referring to, sir? Yes, tell us. 223.
But I have not something when but one of them that was promoted and taking note of my something, my people. And then by the year 2018, showing my name in the gradation list in between my law. Page number 678, page number 227. Then at the relevant time, I was not.
Your name is?
Page number 7.
I
PL number 7 and 15. Taking note of the addendum at page 50.
Yes, sir. We'll answer it here. Please have page 223. The covering letter. Please read the name of Pavitra Mohan Deka. That is the petitioner.
My lord.
In between Pranab Sharma and Mokibur Rahman in the gradation list of undersigned. Yes?
My lord.
So his name has to be in between there. If his name is there in between the two persons who were under secretaries,
Yes.
didn't that he had been afforded his promotion?
Yes,
If
that
that
is
be
now-
so,
Yes, in the seniority list, my lord, if it is inserted.
he is there. So if he's there, can you deny him the benefit which you have given to others? In that list? From the period, from the date of his promotion and the actual, and the date of the promotion of Mr. Konok Sen Deka. That in between, he will get what he had got. Yes, we'll close the chapter now. Huh? That was your only credit. He never got to be an under secretary.
My lord.
You will verify this 223. You would verify this at your office level. Respondents would verify.
Yes, first we would give the, my lord, addendum number, my lord. They will verify.
Now, we will reflect this addendum in the order.
Okay.
And you will verify the correctness of it.
Yeah.
If it is found to be a genuine addendum, then the petitioner will be held to be entitled to the benefit that has been given to others under secretaries who were promoted later than Konok Sen Deka, and they have been given the benefit of a notional financial benefit or actual financial benefit as per this 246. Whatever is there in page 246. Yes?
Well,
okay. Correct us wherever we go wrong on things. But Mr. PM Deka, Learned Counsel appearing for the petition. Anybody else appearing in the matter for the respondents?
no.
Mr. B. Gogoi, Learned Additional Advocate General, has entered appearance for all the respondents in the, all the respondents. The petitioner had joined as a lower division assistant in. Where did you join? In the General Administrative Department, comma, Secretariat Branch. On 3/12/1975 and was promoted to the post of Upper Division Assistant with effect from 27/10/1957. The petitioner was promoted to the post of Superintendent by the order dated 1/9/2006 and he discharged his duties as such till the date of his superannuation from service, that is on 28/2/2009. During the course of time when the petitioner was in service, the gradation list of UDA prepared by the respondent authorities on 31/12/2002 had been put to challenge in appeal number 21/8EA of 2003 before the Assam Administrative Tribunal at Gauhati. The appeal was disposed of by the judgment and order dated 13/6/2007, whereby the gradation list whereas 31/12/2002 had been set aside. And the official respondents were directed to finalize the gradation list of UDA under the rules and procedures and the prevailing circulars in determining the interested seniority of the incumbents in the department. It is relevant to note here that the point of reference for determining the seniority and future promotions of the incumbents in the department was correlated to one Konok Sen Deka, who, according to the appellants before the tribunal, had joined his services much later than the other incumbents in the department and was junior, at least to the petitioner. Complying with the orders of the administrative tribunal, a gradation list was published on 17/3/2007. Full stop. By that time, the petitioner had already been promoted to the post of superintendent on 1/9/2007. Later, the point of reference, the person holding the point of reference, that is Konok Sen Deka, had been also promoted to the post of undersecretary, without considering the cases of petitioner and other similarly situated persons who claim to be senior to the said KS Deka. It is the case of the petitioner that several representations have been filed. And acting on the aforesaid representation, which are not a part of records in this case, it is the case of the petition that the respondent authorities had decided to extend the benefit to 110 number of superintendents who were granted promotion on a date later than the aforesaid Shri K.S. Deka. Full stop. Where is that order granting the promotion? Yes. The order dated 31st of July 2013, which granted the financial benefits on retrospective promotion to the serving office superintendent from the date when Shri K.S. Deka had been granted his promotions is reflected herein below for ease of reference, page 100. The petitioner's name appeared at serial number 84 of the aforesaid list, and it is an affidavit position by both the contested parties that the petitioner had availed the benefits given in the said context. Next paragraph. As has been noted here above, the when she case Deka had been given the promotion to the post of undersecretary on 5/10/2007. Full stop. Since the said incumbent was admittedly junior to the petitioner and other incumbents, the respondents attempted to correct the sufferings of the senior personnel by preparing a gradation list by office order number page 11, area 8. So, so can we put this? Underline for office number. SAE.98/2007 oblique par dot Roman 2/12 dated 5/12/2015. Full stop. Unfortunately, the name of the petitioner did not figure in the aforesaid senior gradation list of undersecretaries published by the department, and therefore the petitioner had again filed different representation. And it is the case of the petitioner that other persons have also filed representations when their names were not, when their names did not figure in the said petition list. Full stop. It is the case of the petitioner that by an addendum dated 7th of August 2018, the Secretariat Administration Department directed that the name of the petitioner and two other persons would be read in between serial number 67 and 68 of the provision of the gradation list published on 5/12/2015. It is the case, further case of the petitioner, that other persons whose name were found to have been available in the gradation list of 5/12/2015 had been granted financial benefit on retrospective promotion by granting them the creation of a supernumerary post from 8/10/2007 to the actual date of joining of those persons as undersecretaries. Full stop. The petitioner, it is the case of the petitioner that when other people in the aforesaid gradation list had been granted the benefit of creation of supernumerary posts and as well as financial benefits on retrospective promotion, the petitioner could not have been left out by the respondents. Full stop. Yeah. What is this page 232? It has a the petitioner has annexed different orders issued by the Secretariat Administration within bracket establishment department of our school to illustrate that persons who had been granted the benefit of a retrospective promotion and financial benefit. Good stop. It is the case of the petitioner that the petitioner should also be granted notional promotion retrospectively and be granted financial benefits arising out of such notional promotion in accordance with his entitlement. Full stop. The respondents have filed an affidavit in opposition. Have you filed an affidavit in opposition, sir? Please. What do you say in that?
Our standard that since he has retired, that superintendent, that
Yes.
benefit was not that.
The respondents have filed an affidavit by stating that since the petitioner had retired as a superintendent in the department, and had never joined, had never joined as an undersecretary, comma, the actual date of his joining cannot be ascertained at this stage, and therefore, the period for which the supernumerary post is to be created and the
No,
petitioner.
that is not appeal. Our stand is that when since he has retired as superintendent, he should not have been promoted to the post of undersecretary even on optional basis, because others have been promoted, they were given retrospective promotion. Like that's correct.
The petitioner was never promoted to the post of superintendent undersecretary in the department and had retired as a superintendent. The respondents claim, allege that the petitioner had retired as a superintendent and superintendent, comma, while the other persons to whom the petitioner has drawn reference to in the various other orders had all actually joined as undersecretaries. Full stop. Since the petitioner never served as an undersecretary in the department, comma, he would not be entitled to any retrospective financial benefit in the post of undersecretary.
1 point, page 227, what a moment was my time. Because the addendum says, my lord, his name should be inserted between 67 and 68. Page 227, 67, 68, lordship will see the date, my lord, when they were promoted to the post of undersecretary. Is 37, 2009, my lord. So in between, if he comes, my lord, then he has already retired in, my lord, 28 to 2009.
I don't know.
Junior has been promoted.
If he is not aggrieved by placing his name in between these two persons, it is your order.
Otherwise, my lord, going by the date of, my lord, and even, my lord, their appointment is, my lord, they are
You
senior.
retired in 2009, February.
Yes, my lord. And lordship will see there's only 37, 2009
Just
promoted to
tell me,
under.
just tell me. Then his name should have been Connoxen Deca is at 39. It should have been before that.
But
Will indicate that you will find out the correct date when he should have been. Because when everybody else is getting, I don't think we can deny.
Lord,
I will not deny.
at least not one and one.
No, sir. With the notional benefits, the fixation of his pension and everything in the post of an undersecretary. At the scale that which he was supposed to draw on the date of his gift. Yes, then what we say? Yes, we have gone to the. No, we have heard this. I have heard the learned council appealing for the contesting parties, and I have also gone from the press records annexed to the petition and the affidavit. Oh, it is there with you also. You have also given it. At page 276, your affidavit contains it. Yes. Addendum.
Well,
I don't think you need to verify this addendum any further. Save and accept the actual position where it should have been posted.
well,
The different annexures which are not in dispute indicate that the petitioner, as were several other incumbents who had joined as LDA, were later promoted to UDA, superintendents, as a UDA and superintendents, were denied their due promotion at the right time, while one Connoxen Deca had been given promotion on the basis of an erroneous gradation list for the post, prepared for the post of UDA in the year 2002. This erroneous promotion based on a incorrect gradation list had a cascading effect on the careers of several persons. And it is an admitted position that the department has tried its best to correct such errors by preparing fresh gradation lists and by giving retrospective effect to promotions to those who have already earned promotions in the department. Good stuff. It is also not the case of the respondent authorities that the petitioner was not entitled to be promoted to the post of Under Secretary on his own term, and that he was superseded on merit, but from the tenor of the pleadings and the submission made, it is clear that the petitioner had missed out his opportunity for being promoted to the post of Under Secretary only because the respondents had on earlier occasions depended upon an erroneous gradation list, which we have already, this court has already seen, to have had a cascading effect on the careers of all incumbents who had joined as, or who were serving either as UDA or superintendents at the relevant point of time. It is also an admitted position on records that corrections had been affected by the department as and when brought to their notice. And in such circumstances, several reported promotions to the rank of undersecretaries were given a retrospective benefit from the date on which Connection Data had been promoted. The addendum dated 7/8/2018 also places the petitioner along with two other persons in between Pranab Kumar Sharma and Mohammad Mokibur Rahman. Stop. The records annexed to the pleadings in the writ petition show that the promotion of the aforesaid two persons had been given effect to on 30/7/2019, and the promotion to the post of Undersecretary had been given on 30/7/2009, and they had joined on 31st of July 2009. Full stop. Mr. Gogoi, Learned Additional Advocate General, points out herein that placing the name of the petitioner in between the serial number 67 and 68 of the gradation list of the undersecretaries also has an anomaly in as much as the petitioner had already retired in the year had already retired on 28/2/2009, and therefore he could not have been granted any promotion on 30/7/2009. This court notices that such a submission appears to be correct. Mr. Be that as it may, it will be for the respondent authorities to reconsider the situation and place the petitioner at the correct position in the gradation list of undersecretaries of the Secretariat Service published on 5/12/2015, giving the petitioner giving effect to the giving effect to the notional promotion of the petitioner from a date at least prior to the date on which Connection Data, an admitted junior had been accorded this promotion. So we leave it upon the department, we leave it upon the respondents to correctly fix the position of the petitioner in the gradation list published on 5/8/2015. Next paragraph. In view of the discussions made herein above, where the entitlement of the petitioner for a promotion prior to Connection Data has not been effectively rebutted by the department, I am of the considered opinion that the petitioner will be entitled for the grant of notional benefits of a retrospective notional promotion will be granted to him ahead of said case data.
Instead of specifying the name, Rossi will say ahead of his junior.
Ahead of his juniors. Stop. Accordingly, this petition is allowed by directing the respondent authorities to correctly fix the position of the petitioner in the correctly fix the position of the petitioner in the gradation dated 5/12/2015 by determining his notional date of promotion to the rank of under secretary and thereafter grant the petitioner the benefits similar to what has been granted by the orders dated 22nd of February 2018. No, 2018, 9th of October 2019. By giving him giving him by taking his notional date of promotion at its correct position. The petition is disposed of, no authorized cost. We'll make the corrections as per. Yes. The since the petitioner has already retired in the year 2009 and others similarly situated have been given the benefits in the year 2019 itself, this court deems it fit to direct the respondents to complete the entire exercise of giving the benefit to the petitioner within an outer limit of 4 weeks or 4 months from the date of submission of a certified copy of this order. Yes, Mr. Sharma.
Nothing. I received the instruction.
We would trust you to read it out to us.
Okay.
You could have read it out to us. Yes, who sends it from the DE office?
Nothing.
Who is sending these documents half done in a half-baked manner? Some officer is doing it, some half-baked manner. Who? Can you trace him out? This authenticated checklist number duly sealed and signed.
What?
So the signature and seals were missing when you forwarded it. Hmm? Today is 26/5.
26.
Yes,
You sent it yesterday.
Yes. It is on.
It's a reminder itself.
Huh? So there is no actual calendar of handling files. The calendar is only of the court case, dates of the court case. Huh?
15/5 it was sent and subsequently this reminder is on.
I don't know the content of the office of the bread. Once we have shifted side, we know nothing. Huh? Personal knowledge and judicial notice are two different things. As per the judicial knowledge of it. 2nd of June.
Today is 26.
Yeah. Today is 26th. 2nd of June. Updated instructions from the Director of Elementary Education. And Mr. P.N. Sharma would be appearing, hopefully. Mr. P.N. Sharma will be appearing, hopefully. Otherwise, without instructions, Mr. Sharma will be assisted by some officer. Huh? Send the correct documents. This is a case where you are talking of, where we are dealing with a person who is disabled, who was required to have been given a job in the year 2015. So this 11 years salary will also be an issue. Date of entitlement. Recoverable from persons who sat over the file. Then you can compare this. Who was appearing in the morning? What is the name? Miss Deepora, Lord Council. appeared on the first call of the matter. Good stuff. Learned Standing Counsel, Mr. P.N. Sharma, appearing for the Elementary Education Department, has placed before this court an instruction dated 25/5/2026, whereby it has been stated that the Deputy Secretary of the Government of Assam had requested the Director of Elementary Education from Assam to furnish the authenticated checklist number 10, duly sealed and signed by all counterparts as requested by the finance, as required by the finance, a finance within bracket SCU department in connection with the proposal for appointment of the petitioner. Full stop. List this, Ms. Chakraborty, Learned Counsel, appearing for the respondent number 1, has submitted that the affidavit filed by the Elementary Education Department would suffice for the purposes of adjudication of this, would suffice for the adjudication of this case, and the respondent number 1 would not be filing a separate affidavit, unless the situation demands any clarification from the respondent number 1. This matter again on the 2nd of June 2026, on which date Mr. P.N. Sharma, no, instruction plan, on which date Mr. P.N. Sharma, Learned Counsel, appearing for the Elementary Education Department, shall inform this court regarding the steps taken in pursuance to the communication dated 25/5/2026 at the office of the Director of Elementary Education. Good stuff. This court, Mr. B.M. Dekar, Learned Counsel, appearing for the petition and form who has appeared on the second call of the matter, has submitted that the petitioner was required to have been offered appointment as early as in the year 2015 itself. Good stuff. He has paid for, and he has submitted that the delay caused by the department is now has deprived the petitioner of her salaries for more than 11 years now. Good stuff. The respondent department shall take note of the above submissions. List again on the 2nd of June 2026.
But after we why but the alternative is 13,054. Why which the family pension is the monthly pension is 45 rupees, 3,194 for the petition, and 759 rupees up to half the and the 705 for the this and the 705. In fact, what I will take over to paragraph 7. Page 40. Correct. at the rate of 8.50%, 1.16%. Of the husband of the petitioner, of the husband of the petitioner, is entitled to the higher of pension. However, as the husband of the petitioner has higher the after the scheme of the reform, they are required to get under the scheme. The petitioner statement after the reform number 5 company, the reform number is the correct and the next phase 19 this particular statement apart from the above, also the petitioner is entitled for the reform number 4 by an order to the 2024 and section mentioned the effect from 12/9/2019 to the start and had two daughters as follows. Currently, a person ordered at 13/2024 the reform number 3 of 4 and to the statement doing the area written page to the petitioner and her daughters the petitioner to contact the manager of our bank.
Now this higher amount, what is the higher amount? How do we find out?
So in fact, in paragraph 14, I have said,
Another person is getting more.
yes.
Who had paid an amount similar to you.
Yeah.
That we have seen. What is he doing?
They are getting 20,000. That they are getting. The higher content
Yes.
but in the everything of now the ability of the person working at that or getting higher than on option of the complicated by the employee. That option coming on they find it but and in the additional evidence again they have taken that that's not I am not saying the 8.6% is normal. 1.16% is the highest. If someone opts to given the option to have the higher pension, that is 1.1%. That the other they agree that yes, that is from the option. But the option comes not available. And that's for that, one of the best. That is the key.
Is that it?
Kind of take up the additional there it starts at big, suddenly big. Just making it page 76. B, towards the bottom. The equivalent subject as per office record of Ado Gauhati subject by its subject after 1/14, the post attachment design, wherein the members of the action would have already contributed to this more than 6,500 divided by the ratio for deducting by 10%. April. So this is since in September, important the jurisdiction of Ado Park State, office of the approach which one of them from Ado Park State, it is for qualified state to take care for Ado Park State for sufficient of one of them after paragraph 11 of 5. In respect of the method, it is for Ado Park State by the 17/11/2023, informed that two stage one option under paragraph 11(4) of EPS of project is available in their report. That is the step. Kindly come to the next page and page 78. In the academic reply, the petitioner has now considered that the equivalent contribution of 1.16% is calculated the possible what's benefit farm. Apart from 8.53%, and therefore for two content that the section on positive is on higher pay, affecting hard to supplement higher pay. It is however it is the people submitted that such section of constitution does not lead to factors and not affecting to higher section in a terms of delivery compliance under paragraph 11.4. The 1.16% contribution is a financial component of the funding mechanism. Entitlement of higher pay is not automatic of the proposal. It is contained
the problem, that's what I was very short option and hoping that of this thing.
So any other statutory conditions not complied with? Is there any other statutory condition not complied with? In this
So,
case?
my lord, in fact, what happened? This has been settled by the Honorable Supreme Court in Sunil Kumar's case.
Okay.
This 1.16% contribution
Ah.
has been helped by ultra virus. Supreme Court has said this will not be operated. This cannot be deducted from the employees.
Okay.
And Supreme Court has given a guideline saying that
When?
in the case of Sunil Kumar,
When?
it is 2021, much after the death of the, and joint options are now being.
So by the time the petitioner had, the husband of the petitioner, it was
Died.
deducted.
Died. It is
Died.
only
So
after
Sunil Kumar, where does Sunil Kumar come in this case?
it is case, because Sunil Kumar, in fact, what happened in 2018, the paragraph 11.11 of the EPF Provident Pension Scheme has been amended. This was put to challenge in Sunil Kumar. Sunil Kumar in Supreme Court has interpreted this, saying that joint option is a must. It is not his option. It is joint option both by the employer and employee. And it is only after the Supreme Court judgment, my lord, the format of joint option has been prescribed in 2023. I'll give you a lot.
So when at that point of time, there was no format. What
No
were you
format.
look-
And
what were
in
you
fact,
looking for? He expired in the year 2019.
19.
There was no form.
No, there is no, there is no question. It has to. Before 2019, nobody exercised. Because
So
it happened
therefore-
like that.
Therefore, prior to 2019.
Yes,
what
that is why they said the joint exercise option is not necessary. Employees went to the Supreme Court on that. And prior to that, the rule was 11.3. That was not amended. 11.3 said the employer and employee has to exercise joint option. This was challenged before the Supreme Court, various high courts and then Supreme Court. In fact, my lord, some of the cases are pending before Honorable Justice Soumitra Saikia and various other cases, Honorable High Courts of the country. And the last occasion, Justice Saikita's adjournment was sought was the matter pending before the Calcutta High Court would be heard very soon. That to avoid that, division meant that to avoid that, this Honorable Court says that let us fix the matter after that. So, my lord, I think as regard option and all, the Lordship may fix the matter after the next date fixed by the. There are altogether 7 and 8 cases, my lord, pending. So, my lord, I think this matter would be, my lord, finally decided. I just, before Lordship, I just placed before Lordship one circular as regard 1.60.
Let us understand the concept.
My lord, kindly see this circular.
For our benefit, when the petitioner husband had joined the EPF, at that position,
Lordship will kindly have a look at this. I'll just read the relevant part. But in fact, Supreme Court, after the Supreme Court judgment, now 1.16 has to be deposited by the employer, whole amount. And this will take effect from 2014. So there is no question of petitioner's amount of 1.416 to be deposited in the fund. Now, if at all he has some deposit made, this will go to his PF fund, not pension fund. That is what this Lordship will find. Therefore, 1.16 is irrelevant. Because Supreme Court has said no.
why are others getting more pension?
My lord,
Then why is someone similarly situated like her?
no, those I do not know about them because they might have exercised joint option because we have said in our
Joint option, your case is that you are not being able to trace out the form.
because he has
Is it
been
your case that they have not, he has
no
not
joint
exercised?
options are available in respect of persons who are available post Sunil Kumar's case. That's for
So nobody prior.
yes.
So nobody should get a higher
No,
pension.
in fact, what happened? This HPC is from HPC. It has been liquidated long back.
Now, these HPC people who have retired from the HPC on that similar 1.4 contribution and whatever, you have granted them a higher pension. Out of
After 2023. After pre 2023 is not. Therefore, my lord, my prayer is Lordship will fix the matter after 18th of June. Because some matters are pending.
Would some other high court be more competent to decide a matter when matters are also?
No, no,
We
our
should
high
be
court,
look-
our
we
high,
look it into those court.
our high. I have no objection if lordship hear the matter, let my learned friend argue, I'll explain it.
Because some other high court, Kolkata high court,
No,
some
no,
high
no,
court.
no,
is-
no, our high
your
court is
matter.
pending. Only. Our high court, it is pending.
Hmm.
No, no, we have not said. So. We have said even if he has some deposit is made, this is irrelevant. We have not said because he has not annexed any document. The petitioner has not annexed document showing deposit of 101.60. This is a presumption. No, no, we have not. We said even if this cannot be, because we are not, because they are the exempted establishment, they have their own PF account, pension PF account. So whatever they done, we do not know. Entire amount is transferred to the pension fund. We do not maintain their PF account. They are their own establishment. They are maintained. I have no problem, my lord. I can argue, but to cut short the thing, I think my lord, the lordship may need to. Because one point is now employers entire
When
amount
is the other matter listed?
18th of June. There's only 7 and 8 matters altogether.
Do you have the numbers?
Numbers.
Have it with them.
I have no, but I understand.
No, then if it is his stand that after Sunil Kumar it cannot be done, we'll have to discuss Sunil Kumar also.
Yes.
Whatever, we were also of the mind that whatever documents are missing doesn't mean that a missing document would in fact give evidence that what is that option was never there. Whether it was exercised or not would in our view become irrelevant when you have taken the deposit. When the employer deposits it, when he deposits it, when the EPF takes the money, it's deemed. But the submission of the learned senior counsel is that even if that be so, Supreme Court has said you cannot do it because of Sunil Kumar case. We do not have this Sunil Kumar case before us.
And in fact, Sunil Kumar is being examined by the coordinate bench. That's why I am saying.
So it is being examined by coordinate bench of this court. Let it be, this is on the 18th of
Only
June.
after that, my lord, only after that, I
Let it be on, let
Even I can
fix
argue
it on
this.
18th of June with the other matters.
Let it be.
If it is in any manner different,
Oh, Lord.
you can apprise the court that
Yes,
this be
yes.
taken up separately. Or if it is similar, you would have your chance to.
No, not similar, but this may have a bearing. That's why, my lord, let it be listed after the. No, not to take.
We'll fix it 2 days thereafter, don't we?
Oh, yes, yes.
If you so desire.
2 days there.
At the request, after some hearing in the matter.
No, let it not be on the same day, my lord. Let it be. Or the next day. Huh? 22nd of June, let it be.
Mr. Nath. Let it be on 2 days after the. There is a reason why we are saying so. Let this matter again on the 22nd of June.
Yes.
2026. On a prayer made by the learned counsel appealing for the parties. No, you strike out that order, you give it like this. After some hearing in the matter, comma, the learned counsel for the parties have submitted that the matter may be taken up on the 23rd of June, 2026
Okay, that's better. This is good.
Since it has been submitted that other matters are fixed on previous dates, on prior dates, comma, outcome of which may have a bearing on this litigation. When you say after some hearing, perhaps, I'll just come back into. Yes.
Department has already directed to release the pension as per OM of 2017 as the minor physically disabled person. But petitioner says that it of 2016 dates again. Her father died in 2016. But as per this notification, no retrospective, it is not.
It is not a response from the date of notification. What to do? there's a notification, just keeping the case alive for nothing will it help. The affidavit will come, result will be the same. Have you challenged the notification? Do you want to challenge the notification? If you challenge the notification, we'll give you it. But if the notification is not under challenge, then keeping hopes alive for another 1 month, how is it going to help? What's the notification? You have it?
Here's the copy of the notification and my instruction also.
So you are now, you have now given that pension from 3/8/2007 from date of notification. 11/3/16 and
Pending.
Huh?
Regular pensions he has been given
the area will now come.
area.
The area will come. You are getting arrears from 2017. Now you'll get it from 2017, the arrear part. And any revisions which have come after 2017, if any, everything after 2017, you'll get regular, whatever arrears are made up. From 11/3/16 to 3/8/17. We'll fix it again on the 5th of June. Kindly file a short affidavit saying, this is the notification. This is the notification and this is what we have now given. Have your instructions if your client is satisfied. Because it is only a matter of 1 year, which without a challenge to the notification, you will not get. You have to challenge it. This is an amendment to, this is a 309 rule. Yes, so it has to be a challenge to the rules under 309 before division bench, that it has to be made effective from the date of death of the person and not of the notification. Miss M. Patoki, counsel. Learned Standing Council appearing for the Animal Husbandry and Veterinary Department has placed before this court the notification dated 3rd of August 2017, by which the financial benefits for claims like the present one would be available only prospectively from the date of issuance of the notification. Full stop. She has submitted that the department has processed the case of the petitioner for payment of arrear pension with effect from 3/8/2017 as per the notification. Full stop. The Learned Council shall file an affidavit to that effect on or before the 4th of June 2026. Full stop. The Learned Council appearing to the petitioner shall have instructions from the petitioner. Full stop. The Mr. C. Bura, Learned AG, Learned Standing Council, Accountant General, has submitted that the case of the the payment of the arrears to the petitioner shall be processed in accordance with law, and that and efforts should be made to have an early disposal to the disbursement of the arrears salary stuff. This again on the 6th of June, on the 5th of June 2026. Two-liner. Just give us a two-liner. June. We will take up the matter. File your affidavit by 4th.
5th is Saturday.
5th is not a Saturday. It's a
50. I had.
5th is Friday.
I said 6th. He corrected me. 5th.
I heard.
5th. 5 June. Have your instructions. Tendency of this case will not help any further. We'll give you the liberty. Huh? Yes. Yeah.
After taking his probation period, he applied for advertisement for the the book. And then he got for 40 crores of time.
Now, in terms of one poem issued by the Department of Personal Training of 1989, where it is 13 7 1989. Now, in terms of that particular poem, basically it brought talent and also to attract people who are working in PFC and other universities and state PFC. Basically, the concept of trade protection was there. So that people working there are attracted to join government service. So in terms of the poem, any mode of selection is conducted to PSC. That particular income tax is selected for any government service. PSC given granted the case. And that was through a presidential order. Now that particular poem was somewhat in the name of verification. Scope of that poem was narrowed down, wherein only those incumbents who was selected only interviewed.
That was set aside by some business.
Since that was set aside not by our high court,
But other high court, OM gone, whichever high court it is.
yes,
Yes.
like by in the subject of the case of Delhi has given on last Sunday those judgments. It followed Sanjay Kapoor also. Because Sanjay Kapoor got dismissed in the Supreme Court, the Department of Peace, on the ground of billion.
Sanjay Kapoor got the benefit from the High Court. They went up in an appeal. It was dismissed. So the land, so the law as laid down by Delhi High Court remains. Okay.
And because of that, now since it was narrowed down, now Delhi High Court says that you cannot choose. Single case or actual nexus between only those who are selected only on the basis of interview, they would be granted the space protection, and those who are not selected on or those who are selected on the basis of written examination and interview, they will not be granted. Cannot draw.
How can that be?
They cannot draw any kind of distinction between. So on the basis, many judges actually follow Delhi High Court. And ultimately, in 2020, the department came out with a law saying we are doing away with this particular distinction. Now everybody will get free. But the petitioner's case is not covered by this subsequent law in 2020.
Right.
Because he got enrolled in BRO year 2015.
So they say after this whoever enters, we give it to them, but prior to this whoever entered will not give it to
So
them.
that is the only thing that, so that's why we are not concerned with the 2020, because it was given its perspective, not perspective. Perspective, not retrospective. So basically, because of that, also the basis of conduct of judgment has.
Where is that clarification, where is the notification that they have given? Now, is 2021?
2020 is a page number 65. Because the petitioner earlier was to come to court. And in terms of this petition from the because of the earlier cut of this petition. I think that department will take the considered to be. But it just passes the mechanical also that we will not. No reason just speaking. Just one line. They just both the facts and just see it. They can also see that mechanical also.
Yes, page.
Mechanical in order of how the principle is page 77.
What is this page 67?
It's the judgment when on the earlier round of litigation.
Saying that they would look into your case again. And
The
they,
night of 2020.
and
Or dignity put this title file of fresh representation. But that page number 77 is the speaking order. The judgment. There after the case. And 78 is the operative purpose of the body. That was not the direction which was passed by the. even never claiming the benefit of voice, because benefit might came during the pendency of the victim. To find it, so never claim the benefit.
What is this page 79?
Page 79, the point is in the state protection. So somebody, now the UPC again came up after 760. So to clarify, the DOPT came up on which, from the ground of state protection in terms of FR 22. Right, and there have been my okay, they have considered because we also my kids have been should have come in the FR 22, but they did not.
What does the UPSC say? Why an affidavit by the UPSC?
We don't have any rules.
One case or two cases?
One.
Yes, sir.
Yes, madam, FPI.
When the entire understanding now is, he will get it.
Perhaps you will not.
Huh?
Perhaps you will not.
Why?
Yes, Lordship may kindly come to Annexure 16 first, madam. These notification of 13/8/2020.
Huh?
Well, this notification has been
His
issued.
perspective.
Yes. That is one. Then again, my lord,
Just for a clarification.
Yeah.
This had come because of an administrative petition or as per para 3, various judgments of this court. If it is due to various judgments of the court that you pass a notification saying that, okay, we don't want any more cases, from now on, no further cases. Everybody gets it. Does it deny a consideration to persons
this is
who are
the-
similarly situated
Yeah.
to persons who got various court judgments in their favor? What do you call it? Amrit Lal Berry. If you have got a judgment covering a particular issue, people should not be coerced or forced to come to the court again and again. And if they do so, there should be a heavy cost on the respondent authorities, which was quantified, I think, in that case at 15,000.
that is there.
Eh?
That is there, I understand, but
That's a
Lordship,
good reason why it should not be done.
here, Lordship, what?
Not on the office memorandum,
Yes,
on the facts of the case.
Yeah.
Give us a good reason why his pay should not be under FR 22.
but that, yes, but for that, I'll take a Lordship to Annexure, my lord, 28 page 79. Even that notification, my lord,
Page 20, annexure.
Annexure 20 page 79.
That is what we had asked him.
Yes.
That DOPT, the OM 5th of August 2020.
Yes, my lord. Even that,
5th
my
of
lord,
August.
yes. 5th of August
This
2020.
prior to your OM.
Yes,
Yours is 13th of August.
yes.
Ah,
5th August, even that
this
notification,
is regarding the 7th CPC.
yes, madam.
Hmm.
Even this order, madam, has been given effect from 1/1/2016. Here, since the petitioner was appointed in 2015, madam.
Because the effect of 7th CPC was from
Yes,
2016.
yes. 1/1/2016.
Tell us one reason why we should not be given the protection, except say that we have come up with notifications at a later date.
That is the only thing, madam, because the notification
Third
is.
paragraph, if you can explain the third paragraph of page 65. Overcome Amrit Lal Berry
Yes,
to say that he is not similarly situated like Sanjog Kapoor.
I leave it to.
No, but tell us. Otherwise,
only thing-
prospectiveness of this 2020 is the only.
Yeah.
And why the delay, sir? When did you join services? When did you not get protection?
I joined on the 17th.
15. Till, and you filed the case when?
24,
No, when did you first make a claim?
2019.
19. 4 years, no claim.
No, I think if you want to pass on 22,
When did you first make a claim? Immediately.
Then it was again set back and forth. Sir, 90 days after signing of.
Now, 19, then you, the 19, it was first rejected.
TTA says that, yes, he will get it, then it will say that, no, he will, with that with TTS, then DGPR says that PTTA will affect it. And ultimately, with consultation with UOPT, they ultimately came out with this order of 2019, this over to get there was a petition. But they are differently situated, that's why they are not, this matter is not technical.
Have a look at Amrit Lal Bedi.
Yes. I have gone through that now.
Amrit Lal Bedi, you can?
Yes. At some point of time, I have forgotten, but I have gone through.
Have you come to Amrit Lal Bedi? No. Then at your request. At your request. Go to Amrit Lal Bedi, give us that paragraph. There was one order from the Delhi High Court, Ravindra something. In that case, the Delhi High Court had imposed cost of 15,000 because everybody was made to come to the court for a particular allowance. Ravindra something, he was a nursing assistant claiming nursing allowance. Good too. So today, because of lots of time, we will not be able to pick the entire order. Third of June. We are trying to spread out the cases so that we can keep it here. 23rd of June, Authorised, allowing Mr. E. Boral on a constitutional PTP to address further on the case. Otherwise,
Yes, but I understand.
when it is already settled, but
But-
we have to do all that notification goes, and your notification says it is pursuant to the various clause. So the notional will get everything. The paper.
All right.
Actuals you will have to convince. Partner. Yes, any response?
Instructions are awaited, madam, because
No, some statement was made that because of state of Assam, that's Upendas.
but
Will not be entitled to family pension.
there is an issue, madam.
When you bring in Upendas,
No, my lord. Now issues happen
One
because there is
wicket
a work
water
charge.
will come in.
This is work charge.
Ah.
And then Upendra's judgment which has been interfered with. It left those class of work charge differently to agitate their grievances for demand to demand family pension and everything, my lord, to the delegate back to the government of Assam. Only master roles were given the benefits that post 93 or pre 93 by any mode of
do you know about the judgment, sir? The
I'll
one we are
share with you.
discussing.
I'll share with you.
Which one? Wait, let me interact with the division bench judgment. Huh? You've gone through it. Now go to another judgment. What is that name?
Well, I'm getting. And there is Sukendra Bhattacharjee.
Take down, take down. Upendra Bhattacharjee
And others versus State of Assam. Civil appeal number 4514 of 2020.
disposed of on
Disposed of
3 days ago.
May 21, 26.
21st of May 2026. Upendas was taken up in appeal. Division bench for that. Come back with that. He is saying work charge will not get transferred. Even as per that, you have to approach the government again. Maybe you can draw a distinction. Here's your name. I have Smigazna, and a council paying for the petition. Mr. B. Ruben, and a council paying for the PH. With a council for the petitioner seeks an accommodation to go to the judgment of
Suketu Bhattacharya.
Second productivity, city liquid number, write it down on a piece of paper.
4541. 25. 25.
Huh? So please the matter again after 2 weeks.
How late?
Sir, the application for regularization of the
Huh?
Regularization.
Regularization.
And can be without paying. But it is in fact we deficit. I think specifically directly responded from all the instructions, whether we have to regularize or not, there is financing. That's not. But I think five. And your opinion also, this one for that some other part. It's the instruction.
Lordship, it was resubmitted on 12/5/2026, Your Lordship. And after that, the instruction that I received that it is under process, Your Lordship, for onward submission to the finance department.
12th of May 2026, from whom to whom?
Lordship, the director had resubmitted the proposal to the government. Your Lordship.
Another 5 minutes time given to you to find out what the government has done for.
Lordship, I had a talk with them and it is under process, Your Lordship, because now they will be sending it to the finance. And they have stated that by tomorrow or day after tomorrow, it will be sent, Your Lordship. To the finance, Your Lordship.
The finances, yes.
Lordship.
Sir, or last year.
Because the joint,
Same situation has been had.
the joint committee has recommended that it should be provincialized, Your Lordship. And for that, since the proposal has been sent to the government, Your Lordship, and that will be sent to the finance. So approval will be required from the finance, Your Lordship. So within a week or so, it will be sent to the finance.
You have not filed your affidavit.
No, Your Lordship.
We will list this again on 15th of June.
Lordship.
Instructions, finance, updated affidavit, whatever you want to file.
Lordship.
If nothing is found on record,
Lordship.
consideration will be other. Give us these instructions on record that you are processing which case that the joint committee has in fact admitted his claim that now the financing should look into it. It is not. File a 2-page. 2-page affidavit, all the instructions. At least once you say that his claim is correct, then we can proceed further. As of today, we do not know anything. Heard Mr. H. Purwa, learned counsel, appearing for the petition. Also heard Ms. D. Mushari, learned counsel, appearing for the elementary education.
Secondary education.
Secondary education. The earlier order, there is 13/5/2026 Act, required the standing counsel for the department to place on record the instructions. Today, the learned standing counsel has submitted that the proposal for regularization of the provincialization of the services of the petitioner would be placed before the finance department within a very short while. Instead of the learned counsel that the joint committee had recommended the case of the petitioner. And therefore now efforts are being made to give effect to such recommendations. Accordingly, list this matter again on the 15th of June.
Lordship, it is the joint sitting of department.
Joint sitting of the
Department of School Education and Finance Department.
in the joint sitting of the Department of Finance and School Education,
School Education.
the case of the petitioner had been recommended.
Lordship.
So, list this matter again on the 17th of June, 2026, by which date the respondents Respondents in the secondary education department shall ensure filing of an affidavit bringing on record their stand in the petition, failing which this court would consider imposition of costs for causing delay in the adjudication of the matter. 17th of June.
Obliged.
Did she approach this court earlier?
Yes.
Let their affidavit be on record. What is her age now?
All right.
She's got 7 years. If you get a job now, because the committee has already given it, you could still join and come back and ask for the areas or whatever you want to. Let this come first. Let them admit on record. Approved by the committee. Then we can go on the rest. Without some admission or denial on their part. It will be difficult for us to say this way or that. Otherwise, several doors will open for them. We don't want that. Already verified. Let them put it on record. Let them put it on record. Yes.
Obliged.
Yes.
Lordship, inquiry has been completed, Lordship. I had a communication and inquiry report has been served upon the petitioner for her representation. And it is in the stage of finalizing punishment now.
Let us not say at the final stage of
Yes, Lord.
punishment that
But-
we will be judging.
Yes. Whatever it be.
Basic change the language of.
Lordship, Lordship.
Yes, your. Now, what do you say? December 2025, the inquiry has been completed and your client has been given the inquiry report. She is not replying to it. They will close it. They will close it, penalizing you, your NIA road. December 2025, inquiry report was submitted to the petitioner. She has not replied.
It is received by her.
5
I have that
months.
copy.
Huh? 5 months. You are not replying to the inquiry report. You think there are signatures. Have your instructions, Learned, Ms. Nempotafiti, Learned Additional Senior Government
Okay,
Advocate
right.
has submitted that the inquiry report has been submitted to the petitioner. And in the month of December
Yes, sir.
2025, full stop.
Received on 25. This is the letter.
Full stop. The Learned Counsel for the petitioner seeks an accommodation to have her instructions on the matter. List again on. 17 June.
Deeply obliged.
Yes, sir.
And because the matter is very limited, our science graduate teachers, not aspirant for the post of science graduate. And we do not have without the mathematics as an honor. Now, without the some of the persons, who have the mathematics in honor, has given the double advantage, they can apply for the post of mathematics as well as below the cadre of the science graduate teachers. So now as a result, what is happening, we cannot go for the mathematics, but they can come in both the categories.
You are science graduate.
We are only science graduate, you know, we do not have mathematics as honor. But in the initial advertisement, there was no any clarity that who can apply in what course. If you go by the initial advertisement, then it is very clear that the graduate teachers can apply in the graduate center in the mathematics and go for the mathematics. But later on, by reducing some of the addendums or some modifications, you know, it has been a classification has been made. Now, because our case is that the person, the teachers who are eligible for the post of mathematics is having the higher qualification in their academic life. When they come in our academy, we have been outside on the merit list basing on the academic merit. So therefore, they are getting the double advantage. In the mathematics also they are selected, and in the science graduate post, some of the person has been selected. Now,
They were clever.
no, we don't.
They took a subject where they will get benefit both
No,
the
no,
way.
we do not know, that the subject will be in future, it will be the situation, then we could have adopt some other measures also. So, with all respect, what my submission is that, today, that the classification which they have made, that the same class of people has been treated, in a double advantage has been given to the science graduates having mathematics and the general science graduates. That's okay. So, we have filed an affidavit also, or an affidavit also, they not a very clear position, So, may be allowed to, can fix this matter, on the next week, Tuesday or Thursday, because they take some time,
Yes. Otherwise, readings are complete.
Yes, sir.
Readings are complete. Because of this, we have learned senior counsel assisted by also heard. Also heard Mr. Counsel paying, standing counsel paying for the education. It's submitted that the readings are complete and the matter will be taken up for hearing. Is there any stay in the? It is
not, the post, then the recruitment is already over. But my instruction is that still post in the graduate cadres are lying there because this mathematics candidate has left these two posts of graduate and opted for mathematics. So I want to take keeping out up and taking the advantage in this category of choice. So double advantage.
18th of June. 18th of June. List the matter again on 18th of June for hearing.
The mother-in-law and the daughter-in-law.
Okay.
I am for the mother of the deceased. I am paying only 1/3 to what extent I can pay. I am not objecting to what the private escort department is related to what we can discuss to the government.
Is it under the compassionate families, compassionate pension scheme or the earlier scheme?
No, no,
Earlier
it
scheme.
is not pension, it's terminal benefit. That which is
Okay. This is.
It's covered by the pensions rules 1969. Now, the last notification, 24th of September 2017. In that notification say,
That is for compassionate family pension.
that's now, after the judgment of the Supreme Court, now the service, compensation service is not, that has been abolished. Now saying that you have to get the salary of last drawn salary up to the date of the superannuation. If the deceased is alive. To that effect, that notification says that the definition of the family, that is in respect of the, as defined in say, pension rule 1960. So in that rule, 135 and 136, the wife is only entitled.
You are the wife because
Now that's the,
because she took care of the person of whose wife you are.
that's right, my lord. We are governed by the rules, my lord. That's the difficulty. It's not a Hindu succession act will not come. May we please that notification? That notification is very clear.
Show us. 5-1 and 5-2 was it. I have only one copy, that's all.
5-1 and 5-2.
Yes.
Have you read 5-1.0?
5-1.0. And that's only my contention is that the definition of the family,
5-1.0. What does it?
that I have only one copy.
Please. That should solve the problem. We will send it for a mediation if you so desire, but 5-1.0 will answer your question.
Yes, now that's, I have specifically said in my affidavit that in fact what happened, my lord, I'm just narrating the facts because this facts is very also necessary. Now that my husband he was met with an accident while in the duty on 18/6/2000 last year. Then he was admitted, he was subsequently airlifted to Gauhati, but unfortunately he died in October. Now I have expended by way of loan, etc., because I am a homemaker. I have also one daughter. So entire expenditure of 19,43,000 which is all having a cash
On
money.
record, yes.
Yes, because they are lifted from Dibrugarh to Gauhati, lordship will just appreciate. So therefore, that money I have expended. Now, therefore, after the ceremony is over, on 14/11, this petitioner has wrote down a letter to the authority concerned to hold the payment and file this writ petition for consideration of that representation. This is the prayer in the writ petition, not beyond that. Now, in my affidavit, I am saying that I approached my mother-in-law to stay with me because I have none other than my mother-in-law to look after me as a guardian. So therefore, this 510, that if I am refused to, provided that if the parents or other eligible family members,
You said the parent, the definition of family as given in what, 5.1?
family pension rules 135, madam.
Says 135.
Of pension rules 1969.
135 of 1969.
Here. The parents comes under Roman 3-4.
135 does not define family.
An officer, 135 redo it 136.
What is 136?
136 not to be fine.
I mean,
Family for the purpose of this rule will include the following relatives of the officer: wife in the case of a male officer. I am there. And other, if
and-
wife, that
and-
is a consecutive order, my lord.
6.
Now,
and
this
7.
clarified in 135.
What is it?
Yes.
Yes,
Sub-
tell us.
Subrule 2, my lord, candidate. If an officer who has completed 5 years qualifying service dies while in service, the gratuity not exceeding the amount specified in Subrule 3 may pay to the person or person on whom the right to receive the gratuity is conferred under Rule 136. Or if there is no such person, it may be paid in the manner indicated below. If there are one or more surviving members of the family, as in item number 1, Roman 2, 3, 4, and 5, the Subrule 1 or Rule 1, it may be paid to all such members other than such member who is widow, daughter, such and such. Now, Lordship will kindly have a look at Roman 2.
Roman 2. Yes.
If there are no such surviving members of the
There are surviving members. You are there.
Yes.
Mother is there. Father is there. It has to be distributed amongst all.
Yeah.
If an officer who has expired,
Yeah.
a gratuity not exceeding
If-
the
if-
amount,
If, my lord, if Roman 1 to 3 is not there, then the subsequent 4, 5, and there will come.
where? Again, please again make us understand. It may be paid to the person on whom the right to receive the gratuity is conferred under Rule 136.
Yes.
And if there is no
So
such
one,
person,
2, 3, and 4, my lord. There is a
if
stop.
there is no such person,
Yes,
it may
then
be
5 will
paid-
come.
it may be paid in the manner indicated below.
Yes.
If there are one or more surviving members of the family, as in item number 1, 2, 3, and 4.
Yes. If they were not there, my lord, then the Roman 5 will come. They will come later. If 1, 2, 3 are
Hmm.
not there, then they
So
will come.
gratuity will be paid between 1, 2, 3, and 4.
Yes, then 4, 5, 6.
Hmm.
So the mother is not, mother is, or Lordship will find 7 last. 7.
Yes, what do you say? Entitled to 1/3? How do you say 1/3? Huh? Pension, is it by legal, or is it by the pension?
Nomination member. Because, Lordship, I'm just explaining, I'm just reading, just assisting this. This notification, earlier what happened? Madam? That during service, then the wife or the sons and daughters are entitled for compensation.
Then mother
Yeah,
and
ma.
father were
Here, now that was changed.
by
And
an-
therefore, the notification says that the definition of
But
family
that
is
510 will come in. Sorry, the notification 510.
5-1 and 5.
No, 510 will come in.
Yes.
The
510
parent is making a complaint.
Yes, if I am refused to look
No,
up,
the parent is making a complaint. Then who will apportion it? The department.
will issue other apportioning the commission, the other eligible thing.
So whosoever
So
are,
for the gratuity is concerned, my lord, I am entitled.
you are asking for gratuity also.
Yes. All, everything. How gratuity will they?
Unless you show us from the pension rules that the gratuity comes from. Sorry, state of affairs, but we can't.
Otherwise, my lord, we are explaining in my affidavit, their statement in the writ petition and their representative, absolutely untrue and devoid of merit. Because they said that
That
I
is
am the
why-
only government
That
servant.
is why the department will apportion it. No one goes into their household fight
Yes.
between a
That's it.
daughter-in-law and a mother-in-law.
That's right.
No one wants to get into that.
And these, my lord, I'm just, and if that rule 510 will come, only I'm refusing to look at. There's no allegation.
There is nothing I can, it doesn't.
Yes,
say-
yes. Members are not looked after by the
When the
compensation family
parents
pensioners.
allege, when the parents allege that you are not looking after, they will simply apportion.
There's no allegation. That's the problem. There is no even a whisper.
That will be before the. Huh?
I'm not looking after. Why?
Whatever, that is not for us to do. But tell us gratuity. Other things which matter.
Provident fund, that's all. Same principle. my lord. Same principle. My lord, my difficulty is, I'm just explaining my urgency and difficulty. Since November 2025, I'm absolutely on the street because on the one end, my lord, the constitutional code, my lord, mine
You
is,
stay here.
no. Because the pendency of this petition, they
How
stopped
many
any
children- How
disbursement.
many children do you have?
My one college going daughters is there. And
So
I'm
you are two of you.
two of them. And nothing, none, not a single penny I am received.
We will give them the liberty to disburse 2/3 of it.
My lord. And subject to outcome.
And 1/3 will be subject to outcome.
My lord, my lord.
There's no other way. You are only entitled to, you are only seeking 1/3.
That's will also
That is
mitigate
very
my
fair.
problem, my lord.
You must appreciate.
Yes.
Mr. Then a council is paying for the petition also, but assisted by
Yes, thank
it appears for the huh? Assisted by the division of IC. The issue in this petition is regarding the disbursement of apportionment of gratuity, the DCRG and other benefits arising on the death of a deceased employee. Which the mother-in-law, the mother of the deceased employee and the, is the petitioner while the respondent number. You are repeating, sir, for respondent number?
3 and 4.
3 and 4 are the wife and daughter of the deceased employee. The counsel for the petitioner had submitted that the mother is claiming 1/3 of the benefits arising from the death of the deceased employee. So the learned senior counsel appearing for the petitioner had submitted that the
Respondent.
for the respondent number 3 and 4 is submitted that due to the pendency of this petition, the respondents have not disbursed even the unclaimed, even the 2/3 of the benefits to which the petitioners have not insisted a claim. The learned counsel for the petitioner has prayed for an accommodation to further apprise this court on the entitlement of the petitioner to the benefit to the benefits arising from the death of the deceased. Accordingly, list the matter again on. We will have
Is
it
it
on
possible,
20
my lord, on the 10th or 11th?
we will have it on 26th of June. 26th of June. It is submitted. No, it is. No, in the meantime, it is. In the meantime, the respondent authorities would be at liberty to disperse 2/3 of the benefits arising from the death of the employee in favor of the respondent number 3 and 4. Since the petitioner does not lay any claim,
Just saying that the respondent number 2, they are the disbursement.
we'll say the respondent of the would be at liberty to disperse 2/3 of the benefits. Since the petitioner has laid a claim only to 1/3 of the total benefits arising on the death of the employee.
And what will be the outcome of this?
We are simply saying that they are entitled to.
I leave it to them.
1/3 we are not saying.
Grateful, my lord.
Yes,
Yeah. I think we reached the order that they not for 2026.
Need with PCC lordship.
Mm.
Your lordship, in this matter, we needed to file our affidavit, but your lordship, annexure part, your lordship, already affidavit got signed, your lordship, but annexure part, your lordship, the relevant type copy has given, not the original one, which I am seeking your lordship for handed over that original copy, your lordship, but not able to get it, your lordship. So your
so from where did they type it?
relevant, your lordship, I can show the relevant.
They are
Your lordship.
they
No,
are
they
typed.
given only relevant type copy, relevant part. The original one, I am not getting. Your lordship.
It is a document of what? It's a
That
document.
annexures, your lordship.
Annexure, no, what is the document? It's a reply by the department. It is
To
a.
the in charge of Molua PICP, that your lordship addressing that the physical harassment of Mona Lisa Das of class
It is some
allegation.
report. It is some
Yes, your
report.
lordship. So your lordship, for which I am not able to file it, so I am paying your lordship 2 weeks time, your lordship.
But that was the submission of 1 for 2026. That has been recorded.
Already, your lordship,
Thereafter, another date has come on the 6/5/2026 contract letter was not released. Due to positive of the particular time. Another lordship. 1 month.
What is your case? Compulsory retirement.
My lord,
You were compulsorily retired.
PPA,
Why were you retired?
Under suspension.
Already compulsory, we get 15 award. That is up to the proceeding. And my experience service period was is less than 2 years.
Regular disciplinary proceeding or based on conviction? Full disciplinary proceeding. He's still under trial.
Under trial. More carrying epidemic in the sample of 50 grams for the
List the matter again on the 16th of June, 2026. Full stop. The challenge in this petition is to the compulsory retirement awarded to the petitioner. Full stop. The learned counsel for the learned standing counsel has submitted that the affidavit, although prepared, could not be filed because of the absence of the originals of typewritten annexures given to the counsel. Full stop. The learned counsel for the petitioner has submitted that several adjournments had been given on this ground alone. Full stop. The respondents should be at liberty to file their response on or before the next date of listing. Full stop. The respondent shall also ensure that the records of the disciplinary proceeding are kept available before this court on the next date of listing. On the next date, 16th of June.
Yes. Original records of departmental proceedings.
Yes.
Produced. I'm deeply obliged.
On 16th, if you do not have an affidavit, we'll take up the records, we'll dispose the matter. That's good.
Yes.
Yes, sir.
Deeply obliged.
it is matter pertaining to simultaneous proceeding. Allegations of serious and I have doubt regard to them. Only thing is that they understand that the response of five affidavit. Besides the preliminary objection affidavit, they are contending that in the earlier round of litigation, the petitioner approached the public court and before the court passed an order saying that the DPC has made the framing of the charge. So they passed an order in violation of that earlier order of the son of the court, and they have initiated the decree before the framing of the charge. Again, that I have approached the summons. During the pendency of the restriction, a charge was framed in the trial. They have filed the affidavit. So this affidavit is not on the marriage perspective. It's absolutely on the point that still the charge has been framed. You don't have anything. But in my petition, apart from that, that prior to framing of the charges, you have proceeded with the decree. I have also taken the ground of simultaneous proceeding. So, but as of now, there is no affidavit filed by the state on the marriage perspective. Well, while filing the petition, the projection is paragraph 14. They said that
No, on the other part that he is going to argue. He's going to take up the arguments saying that parallel proceedings, same witnesses, all these points will be taken up. We'll have to consider that part also.
in fact, logic on that premises, the projection is for that only to the extent that till the framing of the charge, the departmental proceeding should not go ahead. But if when the honorable court has considered, page number 88 is the order. When the honorable court has considered the matter, it was placed before the honorable court.
If you look at the prayer
Logic.
at page 22,
Lord,
direct the respondents not to proceed when the criminal case is pending.
but my respectful submission is
Criminal case should be pending only on the framing of charges. Yes? So he is praying that even if the charges are framed, please ask them not to proceed. You'll have to answer that.
but what the petitioner is trying to do now. He's changing the code. Look, why when the order
That is
was
the beauty of Article 226.
No, Malak, cannot be, because he cannot play with the court order. No. Page 88, what was?
Court
A?
said don't issue a notice till the framing of charge is done. Yes, it was done. You issued a notice prior to the framing of the charges.
Yes.
So that show cause notice being in violation of the orders of this court can go. As of today, it can vanish.
In fact,
As of today, it can vanish. We will not, if we don't take into account the other circumstances. The circumstances which happen, which is the framing of the charges by the trial court. Now, once the trial court frames the charges, and we take into consideration that those charges and the charges framed by you, the witnesses which will be brought before each of the proceedings, the gravity of the offense which is alleged against him, can we shut our eye and say we will not look into whether the proceedings should go on or not? Can we do that? When the prayer is, please ask them not to proceed when the trial is going on. Department proceeding at least till the, at least for a year.
look,
I understand.
in fact,
Legal understanding.
in fact, Malad, kindly see, by order dated 5th of December 2025,
You were wrong in proceeding.
we have said
You were wrong in issuing the charge sheet. Would have been a contempt.
Malad,
The memorandum of charge being served prior to the framing of the charge sheet by the criminal court. Self a contempt.
no, kindly see.
You are
that
trying to overlook that,
show cause was given to him in the month of December 2023.
very good.
He came to the honorable court. and
When
they-
were the charges framed in the
and the-
trial court?
on 7th of March 2026.
You gave it prior to that.
No, well, that is why I'm repeatedly referring to the order of.
Please.
Page 88, page
Where is
88,
page 18,
88.
88.
So that first of all, page 84 is the charge. It is a show cause given to him. This is the show cause given to him and he was asked to submit his written statement. Then Malad, he approached the honorable court. Kindly permit me to read the order on page 89.
Now, evidence is there for him to contest in the trial court. That could come into knowledge only in the year 2026. Yes. Now, his allegation is that those evidence and this evidence, that charge and this charge, both should not go together. Keeping in view the fact that there is a criminal proceeding, departmental proceeding can wait for some time. That he can only come up in 2026 could not have been decided in the year 2025. Could not have been decided.
When in December.
Filing of the written statement and further proceeding, the department proceeding initiated against the petitioner shall remain suspended till the stage of framing of charges. Thereafter, it will be open for the authorities to proceed with the departmental proceeding in accordance with law. Now that the charges have been framed, you are at liberty to proceed with the departmental proceeding.
We have asked him.
Subject to the other provisions of law which will govern a disciplinary proceeding. One of which is two should not run together if the charges are same and if the evidence is the same. He is only pointing out that you have not answered that part of the writ petition. If that part of the writ petition is not answered, he would be impressing upon doctrine of non-traverse, which we are trying to convey to you would be against you because there will be nothing on record. So if in case you want to controvert that, you can have an affidavit in opposition, file, so that at the point of time where he starts the arguments, you would have something to stand on. We are not staying the departmental proceeding any further on any other ground. If it is already stayed, it remains stayed. If it is not stayed, it doesn't remain stayed. But you would have to give that answer first.
Lordship has passed an order while issuing notice for Lordship has passed an order
Ah.
not to insist.
Not to insist. So
Because
have
on
your
that
affidavit
day-
in opposition?
No, on that day, when Lordship has issued notice here,
Ah.
charge was not framed. In the meantime, it was in the month of February, 11th of February. 11th of February, Lordship has said that don't go ahead. Subsequently, on 7th of March, charge has been framed. So we brought it to the.
Keeping,
notice of the
keeping,
Honorable Court.
keeping all that in view, by order dated 27/4/2026, this court had taken into account your submission that interim should not be continued, yet for the ends of justice, it was continued.
Because my. learned
Now
friend
the
had-
end of justice is
Learned-
turning to you. If we go by the doctrine of non-traverse, we can dispose of the writ petition now, saying that there is no contradiction by the respondent authorities to the allegation or assertion that they are on the one and the same footing, and therefore 1 year time he gets. What was the case? 1 year time? Extension.
But in that.
Or
in
we
that
can
case-
give you the time to file an affidavit for 2
No,
weeks.
no.
Ask you not to insist upon, with the disciplinary proceedings. Decide the matter whether they are on the same footing or not.
Not, let me come up again.
Now the interest of justice is
Yes, yes.
on your table, if we understand correctly.
Not true.
If you want to do it, we can do it on the next
I'll-
Tuesday
I'll-
itself. No reason. Mr. D. Natlan, senior government advocate, has submitted that an additional affidavit would be filed by the department to bring on stand, or bring on record the stand of the department as to whether the two proceedings were based on the same set of allegations, the same set of allegations, evidence, etc. Stuff. Accordingly, list the matter again on 11th of June, 2026. The interim order passed earlier shall continue till then.
Fifteen.
15?
The interim.
It continues. Interim order continues. Yes. Are you filing an affidavit, sir?
I have received instruction, I'll file it.
If you place the instructions, how does he know what you are arguing on?
I have received, I'll file affidavit.
Or he can give, in other cases, the petitioner can start giving you the instructions from the clients. Would you be able to defend it? When?
Within 2 weeks, I'll file.
The Learned Standing Council for the Higher Education Department has paid for an accommodation to file the counter affidavit. Stop. The pay in the petition is for payment of salaries for 3 months. That is January, February, and March 2025. A March to May 2025 full stop. The respondent shall ensure filing of the affidavit in opposition on or before the next date of proceeding. List again on. List again on. Yes, sir.
18th or 19th.
19th of June. 19th of June. 11th of June. 11th of June. Yes.
I know.
Next. Yes.
Despite the cooling period of 6 years after the secretary state of money, given the circumstances of Impact, money, whatever happening is there, he wants to be transferred out there, the money to somewhere near. And whether the last occasion, goal of.
Document, look into that remarks column. Out of 31 years of service, he was at Northeastern region for 29 years. Out of 31 years of service, he was within Northeastern region for 29 years.
At his request.
And 20 years he was in Manipur. 20 years he was in.
At his request. Was it at his request?
May not be.
Does he have an indefeasible right to get?
No, but he has an indefeasible right to get his representation considered in the right manner.
That reason has been stated in column number. Remarks column.
Why the extract of recommendation of Board of Officers? Why can't we have that file saying this is where the Board of Officers has signed it? This is their discussion. This was a discussion by the Board of Officers.
It's not only his case was taken as a isolated. All the case was considered in a single board meeting.
Yes.
So that.
How
was
many cases?
Maybe, or because it's somewhat changed.
How many cases would be considered on a single day, on a single meeting, by a single board?
That exact
We have got around 16, item number 18 now.
20.
Now we are doing item number 24 now. How many cases were considered by them? Is it humanly possible, the way it is done?
Lordship, whether transfer cases will be subject to such microscopic review, Lordship.
When
Unlike the disciplinary proceeding.
when the transfer orders are by
And
are
looking
on
into the case, he was in.
are on administrative need, and the respondent authorities can show that we need this man out. This is because of transfer.
No. Not this we
For
need.
anything and everything that he has completed this many of years, therefore please go. We understand that.
Lordship,
When an
because
app says that this is the
Santos, it
calculation.
is done through
goes.
Santos, Lordship.
Santos. So it's an app algorithm. It will not know what is the difficulty of any person required to be considered or not to be considered. Whether a person was on attachment, shown posting at Jammu and attachment at Gauhati. We do not know.
Lordship,
Now,
Bangalore
all
is a,
this taken into consideration when the matter is placed before a board of officers.
it was the
What
place
did
before the board.
What did they do is only what we are asking. How did they do it is only what we are asking. That this was the sentence spoken. Finished.
Lordship, that remarks
Seen,
column, remarks
rejected.
column says so, Lordship.
No,
What has been
remarks-
considered?
Who has given this remark? That is why we are saying that
The board.
that small part where this application was considered is all we need to see.
Lordship, what more need to be cited, Lordship?
Extract will not be. Remarks are by whom?
Lordship, except the recommendation of board.
Remarks are by whom?
The board,
No, recommendation is by the board.
Lordship.
Remarks is by the department. By the person who wants him transferred out.
The recommendation of the board is recommended.
Not recommended. So
Not-
this was the remark of the board.
Lordship. Not
This was the
recommended.
remark of the department in putting up the application.
Looking into this, his case for modification was not recommended.
The date is very important. My rejection is that character L to be 79.
Hmm.
And what I could see from a bare eyes, my that extract has a date of 21/5 attested, but it doesn't reveal when it said this board. It says, but I say 19th
No,
September.
no, it's a unit.
But it doesn't reflect any date.
During the 2023.
No, but that board, I mean, it's corrected if I'm wrong, that doesn't say anything. Doesn't reveal when this meeting actually happened. Board set. But has to be beyond this date, earlier to this date.
When did the board sit?
Indicate, because on the earlier date also some instructions are placed, some WT message. Doesn't indicate anything when did it books. Only says that board rejected.
Page 79, Lordship,
Of,
writ petition.
no, this is the order by the DIG that the board has rejected it.
Okay.
Is it not? When did the board sit?
So, prior to this date, Lordship is within this sector for 29 years. Only once he was in Maharashtra, and where he have been sent to Bangalore, much better place.
Heard the learned, heard Mr. Digogo learned counsel appearing for the petition, also heard learned, also heard Mr. B. Chakraborty learned counsel, learned standing, CGC appearing for the respondents, full stop. The CGC has produced an instruction dated 23rd of May 2026, where an extract of recommendation of Board of Officers in connection with representative preferred by so and so against his transfer, by the petitioner against his transfer, has been produced before this court. Full stop. On going through the instructions, it is seen that the recommendation of the Board of Officers has not recommended has been recorded in the extract. However, no other details regarding the regarding the date on which the board had considered the application of the petitioner and the consideration on which the recommendation had been rejected are available. Please place this matter again on. You have filed your affidavit of opposition. Would you like to file one?
If the reason is to be stated, we can that only, otherwise.
No, we just
That
need
will
to-
be our ground.
We just need to have the full details as to this was the date on which the Board of Officers assembled. This was the document which was placed before them. This was the file number regarding this petitioner, or was it one big list where 233 persons are there, everybody's are there, and it is simply recommended, non-recommended, recommended? Or is it where you put up one file of one person, this is the transfer order, this is his history, give your comment. What way is it done? Santosh app has got a very big drawback, let me tell you. You can confirm it. You cannot fill up certain,
Much more.
no, one cannot fill up certain preferences.
But to
The stand taken
to
in this,
minimize human interference,
No,
that's
no,
why the.
no,
app has been-
here the stand taken is that he should have been very careful in filling up his preferences. Santosh app does not allow filling up of certain preferences. If you spend some time in a particular locality, you will not be allowed to fill up that locality.
Yes, that is what exactly.
So
He has been in this region for
man-
29 years.
So the allegation that this man should be careful when he's filling the preference does not stand. He's not allowed to. He wanted to put in Manipur. He will not be allowed to.
Because he has spent 29
True.
years.
Therefore, he stand taken in the instruction that he should be careful when he's filling up. Can it stand? No. Even if he's not careful or he's careful, he cannot fill up Manipur. His care does not matter.
And merely for the reason whether he can withhold the transfer, I want to get my reason.
I want to get my
Reason why it has been rejected, or that whether he can withhold the transfer.
Let us see. You would file your affidavit by what date?
Not affidavit.
Choose a
Within
date, sir.
week time.
Huh?
Within a week time.
Within a week. So we'll have it on today's 26th. We'll have it on the 9th of June.
Okay.
9th of June, 2026.
An endeavor shall be
The-
made to dispose of it.
An endeavor will be made to dispose of the petition. The respondents would be at liberty to produce records to show the manner in which the representation of the petitioner
Or we can
have been-
explain in their affidavit.
I'm saying I would be at liberty to produce the records also. You can explain whatever you want to in your affidavit. Stop. Interim orders granted on 18/5/2026
Till the next day.
shall continue till the next date.
May I please kindly pass over the matter to the Lordship. Short recommendation, Lordship. On 7/6. Court,
We do not have an option also, we have to
on
pass it.
Lords, on fifth, on fifth.
Fourth is a hearing day. List on fourth due to positive time today.
Online.
It was heard by a particular bench, the order reflects. Should it go before that bench? The order says matter is heard to a certain extent. Should it be before that bench or? Because today we do not have the time to start a hearing. It was not directed to be part heard, but still it says that the matter is heard to a certain extent. We do not overwrite that. A list again on the 9th of June 2026. We'll simply say list again on. Due to paucity of time today, huh? Yeah. Huh. Your allegation was that there was only one person who had appeared. And just because it was one person, you were not given the appointment. The college says that maybe one person, but we have not received any complaints. Other people had applied, other people were invited, and the selection has got no default, no fault. And the director of higher education says that we want more competition, keeping a post vacant, not allowing the students to study. We want one more person. Yes, tell us.
Call for the report.
No, why does this one man?
Complaint was there
From whom?
from some persons, Lordship.
Who? How are they connected
No, how are they connected?
to the selection process?
Because Lordship, the allegations is very serious,
What is the allegation?
that the authorities wanted to get the only one person selected, blue eye.
Ah.
So the directorate has asked for a report from the principal also.
Hmm.
Principal has not given the report.
Yes, now that other persons not appearing,
7% out of,
they did not appear. Why?
that's the, they have not.
No, they have not appeared.
They have
Because all those other persons who had applied in the college wanted the blue-eyed boy to get the job. When the entire world is against you,
not that.
the college is against you, the petitioner is against you, the persons who are supposed to participate are against you. Have you taken up this grounds in the affidavit? No.
In the affidavit, we have taken that, actually only one in the. There are 4 and 5. 4 and 5. Regarding absence. No note, no remark in the remark, that why absence is there, that is nothing was there. At para 5.
How does it take away his merit and his participation? Is there any law to say that if one man shows up for the interview when 7 are called, he will not be given the appointment?
No, but from the report, the record, it reveals that the complaint was there.
Report from whom?
Record from the college.
There is some complaint saying that one person, he was allowed to appear.
No. That other persons that they, authorities wanted to appoint this petitioner on. So they, other persons will, that they did the process, Lordship, surreptitious. The entire, the committee, the selection.
Any of those persons who had applied has made that complaint?
Any of the
Persons who had applied for that post has made that complaint or no?
no, Lordship, no.
In fact, we did not receive any complaint. We have stated in our
Lordship ने पेरूस record.
16th of June. List again on 16th of June as part of 18th of June as part of the The records will be, records or all authenticated copies of thereof would be retained by the direct counsel paying to the respondent.
Obliged.
Why this review?
May please, Lordship. I am appearing for the private respondent, respondent number 7, Lordship.
You are filing your affidavit?
Lordship, I have not filed affidavit, Lordship. May
You like to file?
affidavit,
It was for the petitioner to
Lordship, may kindly bear for a moment with me. Apart from the order they have sought for review, there are two judgments in favor of the respondent passed by this honorable court, Lordship, directing something to DC. DC did not carry out that order. Therefore, we filed an IA. In that IA, this honorable court specifically directed,
Are you arguing the matter, sir?
Lordship,
In the absence of the petitioner,
Lordship,
was it done in your absence? Did we
While
hear
this-
him in your absence?
the consent is without representation till date. Therefore, I am submitting.
You
I
are,
have
you are the elected member.
I am elected member.
And the panchayat is suffering because you are not
Yes,
participating in it.
Lordship. Therefore,
3rd of June. কিমান হব 3rd of June? এটা কিবা আছে নি? 3rd of June.
there is no stay, even DC is not giving oath taking, Lordship. There is no stay.
3rd of,
And there is specific direction of this honorable.
3rd of June. In his presence, none appears for the petitioner today. Mr. Swinton appears for the private respondent. List again on the 3rd of June. In the interest of justice.
I will see in fact, let me file affidavit. Respected, I have filed by the person.
Mr. J. Henry, Learned Counsel.
Matter may be put in admission after 2 weeks.
Mr. J. Henry, Learned Counsel appearing for the respondent number 1 and 2 has prayed for an accommodation to file the response to the interlocutor application, allowing the same list list in the admission column. And a list again on 10th of June 2026. 10th of June 2026. Mr. Hendrick submits that the matter may be taken up for admission on that day. Stop. Interim orders passed earlier shall continue. When did your selection process start? When did your selection process start?
I was appointed in the year 81.
Yes, sir. You won't file an affidavit?
I not last regarding steps, my lord, SCRT. And appointing authorities, SCRT.
Have you given copy to the SCRT? Copy was given to the SCRT, process reflects.
No, for the topic.
It's the matter again on the 5th of July, showing the name of learned pending counsel, the pending counsel SCRT in the conference.
Public.
Yes, sir.
Cannot be possible.
2018, yes. 2018. We will try it on the 18th of June.
If it is not inconvenient, if it is inconvenient,
No, we are actually filling up the dates on hearing dates on matters which we have heard to some extent. 18th of June, we can make anything. List again on the 18th of June, as there is paucity of time today. Stop. The matter is of 2018, and the parties should be at liberty to make a mention for upgradation on 18th. So, no, কিমান পুৰণা ফাইল একো দেখা নাপায় 31, 32 yes हाँ हाँ district Shirang yes
The computer assistant and other another safety servers. Was last in the month of March, department that has passed taken a decision regarding lordship continuation of service up to age of 6 years in respect of contractual and
open das हाँ
lordship. Lordship, in these cases, lordship, petitioners more than above 45 lordship. Others are lordship 45 below. Lordship, time be allowed to some time to take instruction from the petitioner who is above 45 years age. They pursue the matter or not.
the learned counsel appealing for the petitioner has submitted that he may be allowed an accommodation to have instructions due to the recent developments in the case. List the matter again on
Yeah, after 4 weeks receipt, there was a various district in the earlier lordship in this case.
16th of July. You'll have the month of June with you. 16th of July. To have his instructions in the matter. Matter is of 2018. On the next date fixed, an attempt shall be made to dispose of the repetition. Earlier two occasions, you have taken time that someone has expired this and that. Yes.
1 week, they will be given to produce the records.
You were given 3 weeks in 2024.
Yes, my lord.
You are asking for 1 week in 2026. Will it be enough? 52 weeks, 52 weeks. 104 weeks gone. One more week. Although the matter relates to the year 2018, a submission has been made by the learned counsel looking for the respondent for another, for accommodation for a week to produce the records. Full stop. There is paucity of time today also, full stop. Accordingly, list this matter again on the 18th of June. 16th of June, 2026. The learned counsel shall, learned counsel for the respondent shall ensure production of the records.
That pertains to my lord, the appointment to the post of LP school district
Ah,
of 2017. She failed to produce my lord, original certificates of her matriculation as well as the high secondary
ah,
for the authority before 31st of July 2017.
okay.
That was the day of verification of document. She could procure it in September 2017, the duplicate copy. Now she wants that she should be done. After that, it is out. There was some overwriting, we objected, then she said that we will produce it, but before the last date, we will not.
None appeals for the petitioner.
Only day, my lord, is just 4 days. Otherwise,
Matter relates to the election and appointment of the petition. It's the P2 learned petitioner advocate general appearing for the respondent authorities have submitted that the petitioner could not produce the relevant documents before the verification committee on the date fixed, and therefore she was and therefore her candidature had not been carried forward in the recruitment process.
yes, sir.
There is also a submission made that the documents which were in fact produced before the verification committee had overwritings on
The
them.
date of birth.
There were overwritings on the date of the birth, on the date of birth of the petitioner, and therefore was she given another opportunity?
Yes. Within that period, my lord. It was not the
Petitioner was
exactly 30
given the opportunity to submit the relevant documents within a certain time frame.
My lord, it was from
which she also
29/7 to 31/7. This is the period, my lord, when it was.
She was given the opportunity to produce it within a certain time frame, which she also failed. The recruitment process was of the year 2017. When was the rejection?
Rejection, my lord, is of, my lord, at that time, itself, in July.
No, you said 29th of something to 29th of something.
No, 29/7 to 31/7, that was the period
Of 2070.
70.
Yeah. Full stop. Although the case of the petition was rejected in the year 2017, she has filed its repetition in the year 2020. Full stop. Accordingly, he prays for a dismissal of the repetition. Stop. Same manner for the petitioner today. In the interest of justice, list this matter again on the 2nd of June 2022. No, we keep it on the 4th of June 2022.
One more part, my lord. On the last occasion, I was directed to have instruction whether there is any vacancy as on that. There is no vacancy, I've got a statement.
We learned from the learned petition PG has also submitted that there is no vacancy with the petitioner can be accepted. You are appearing in the matter? Yes, Mr. Roy appears for the six who submits that the
My lord, we,
documents are big.
no, my lord, we have verified and found tally with the record.
Mr. Roy appears for the SEBA
SEBA, earlier SEBA,
and erstwhile SEBA. Now,
now Assam State School Education Board.
both some state legislative board. Yes. This is someone challenged your provincialization, you were required to go to the tribunal, he made a challenge, it was dismissed in default. So now you say that your provincialization should continue. Why not? Why not? Have your instructions, why not? Short issue. The challenge to his provincialization fails. Continue. Did you withdraw it? No.
On 12th of April.
12th. 12th of June. Fine. Please taken on the 12th of June. Due to positive time today. Yes, sir. Hmm.
At the time of the assumption, it was very clear.
At the time of assumption.
Release around another day.
Is we require some document. 23rd of June. 23rd of June. Right. Next again on the 23rd of June. This was listed for hearing.
Yes.
Due to positive time to the another counsel for the petitioner has submitted that the promotion of the petitioner was interfered with, that it was not given effective by the respondents only on the ground that he was found medically unfit on the date of assumption of the promoted rank. Ah. How long an order do you expect? Mr. Abedin, how long an order? One sentence. Paucity of time. Not that. I think the one is there something that. Judgment deserves some. But my tentative view was that.
Earlier occasion when we submitted it. Question number 7.
Her name was not sent for and your names were sent,
2011.
although you are all working admittedly. Admittedly, all were working.
Yes,
There is no demand.
No dispute is there.
But because we did not have the education for article numbers,
That is for 2011.
2011. So if it was had done that, if I make it, then we now, this court directed that are things to be considered Also, because the 11th is not there, no, the provincialization granted would only have affected 2007. So, no, there's no such thing. There's. By default, they did not set, that is, once we. But if there is a, it's still clear.
It's the first litigation. Yes, there is no
Then,
such.
you are doing for again for them. Because it was not checked and it was checked after their things being potentialized. And therefore now you see that my name is checked at the first of the then.
Yes.
Then I would have been provincialized even under the act and one of them would have been, yes, probably the other one is not because of the number. Check it. Anything more you want to add to? Any how you have to do this? How, what does it say? Just tell us here that we are running ahead of it. Thank you. What's phone number? Yeah, and what do you say? We got parking for 250. Paragraph 13. There is a non paragraph 13. Now, public to wait time, but we are one is not. We don't know. We are upon. To accept it, that is, without the required qualification, we can unpack the particular on the case for potential. Then, by the time it outcomes of not final case, a provision requiring the required academy for particular is, for example, if you get the veteran city of master city and educational qualification like that, what I important. In the case of that provided full speed. What does it say? What does it say that if the education qualification is not there, name should not be sent? No, something like that. No, then it's not. They have gotten credit to other 11. No, what? Why are you reading these paragraphs? What do you want to say on this? Relevancy to this case. I'll revert to the mind of it. 4.3. It is 4.3, it is 2011 Act, 4.3. There is one provision that 55% degree requirement is required, and there is a provision. It is going to provide for it. This provider is part of the provider. That provider that is the special qualification. Electrical degree for 5 years is only for special qualification and not for the minimum required. It's not for the minimum required. All the fine. I don't, I feel fine. Only I can receive fine. Correct. Working there, if better one for decided by the demand and pressure of that. We have nothing to do with the development. It is only 17 when my date was not that again. Anything on 17? Why did not send his name at the first time? 17? Yes, they was 17. Why not with the other 2%? Not on the first round. You send it on the second round. First round you send only 2 names. Then thereafter you send her name. Why did you not send it on the first round? First round, I don't send it to what is the acceptance there? Our market in our market. And they always difficult. And it goes into a hard, certificate of 1991 was not submitted by her. Therefore, you are unable to complete her. Because it depends on the ability. But thereafter she gave it to you, thereafter you gave it. Well, thereafter she will give you something. So thereafter you have again sent them. Yes. Even in that case,
So here it is not there, man, in the 2017 rules. Those are 11 seniorities there.
Thank you. CV.
JV.